Good morning. It is 10 a.m. Tuesday, July the 14th, and I would like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin this meeting, I would like to bring to your attention, there's a sign-in sheet on the table by the door, and if anyone that would like to make a comment about an agenda item, please indicate by your name as you sign in. Public comments will be accepted near the end of our board meeting. At this time, Ms. Bohannon, would you please call the roll?
Tim Wheeler,
Here.
Don Haynes,
Here.
Dr. Tracy Allen,
Here.
Randy Nash,
Here.
Scotty Porsche, Chris Lee,
Here.
Wendell Naylor.
Here.
Mr. President, we have a quorum.
At this time, if I can get a motion to adopt the agenda.
So moved. Second.
It's been moved by Mr. Lee and second by Mr. Wheeler. No questions. All those in favor got the sign of aye. Opposed has the same. At this next, if I can get an approval for the minutes of May 12th meeting.
So moved.
Second.
It's been moved by Mr. Lee and approved by Mr. Nash. All those in favor?
Aye.
Aye.
Opposed has the same. Motion's carried. Mr. Bryant?
Good morning, board members. And before starting, just recognize that we have two of our summer interns with us, Aya, who is with Belmont Law School, and Phillips, who is with Vanderbilt Law School. We're lucky to have them, glad they could sit in. And if you all ask me any questions that stump me, I'll pass it on to them. When I started in this position, I probably needed about 3 legal reports to get to this number, and they're getting all of these in one go. So this is a good one for them to sit on.
Welcome to the show.
And complaint number 1 is complaint number 2026-027051. This case was administratively opened following a routine inspection conducted on April 17th, 2026. During the course of this routine inspection, the inspector observed the following. The website for respondent establishment displayed a photograph of the owners of respondent establishment. One owner is a licensed funeral director, while the other owner, the wife of the funeral director, is not. And there was no information on the website to show that she was not licensed. Respondent stated the website has been adjusted as of the date of the examination to reflect the appropriate verbiage, signifying the other owner is not a licensed funeral director. Additionally, 2 billboards displayed a photograph of the funeral director owner and his wife, stating they were the owners of respondent establishment. However, the other owner is not a Tennessee licensed funeral director or embalmer, and there was no information to show that she was not licensed. Respondent stated that the billboard is being updated to reflect the changes required. Respondent provided a copy of the new billboard design, which designates non-LIC below the woman owner's name. Based on the above, we'd recommend a letter of warning.
You heard, board members, you heard the recommendation from legal. Any questions?
I make a motion to approve.
Second.
This motion made by Mr. Nash, second by Mr. Lee. All those in favor, sign of aye.
Aye.
Opposed has the same. Motion carried.
Next complaint is complaint number 2026-028531. This case was administratively opened following a routine inspection conducted on April 20th, 2026. During the course of this routine inspection, the inspector observed the following. Respondent observed a new sign being completed advertising the name of the establishment as a name that did not match the registered name of the establishment. The inspector returned on April 23rd, 2026, and observed that the new sign advertising an inaccurate name had not been covered up and was still visible to the public. Respondent replied, acknowledging that the signage displaying a name that did not match the license was visible at the location during the inspection. Respondent stated the sign had been placed as part of a preliminary planning and branding discussions for a potential business concept and was not intended to represent that the establishment was operating under an unapproved name. Respondent stated no services were conducted under that name, no contracts were executed using that name. Respondent again acknowledged that the sign remained visible during the inspector's return and that arrangements to cover the sign and submit a name change were underway. Respondent stated they have since ensured that all public-facing signage reflect the properly licensed name. Additionally, outer burial container price ranges did not match the range of prices listed on the outer burial container list. Additionally, the immediate burial price range did not match the options listed, and the second option for an immediate burial did not have a description for the casket that was listed in price. Respondents stated these discrepancies were unintentional administrative inconsistencies resulting from recent pricing updates, and that following the inspection, respondent reviewed all pricing documents in detail and revised the GPL to ensure consistency and compliance with FTC funeral rule requirements. Based on the above, we'd recommend a $750 civil penalty, authorized via consent order, and formal hearing if necessary.
Board members, you heard the complaint. Any questions?
Did this respondent submit a name change request, or was there something that's?
At this point, I'm not sure if they have. Based on their response, it seemed to imply that once they got to that stage, that a name change application would be coming. I'm not sure if we've received that at this time.
So they,
Oh, and Mr. Ribble has confirmed that we have received that name change application.
okay. All right. Has that been approved already?
Yes, it was submitted sometime after the complaint was open, and then it's been approved.
I make a motion to accept the recommendation.
Second. Sorry.
It's been moved by Mr. Nash and second by Mr. Haynes. All those in favor, aye. Aye. Opposed, has the same. Motion carried.
Next complaint is complaint number 2026-030421. This case was administratively opened after an inspector for the department drove by respondent's location on April 29th, 2026. The inspector observed respondent's funeral establishment sign covered with a sign that said available, with another available sign located in front of the building near the entrance. When the auditor stopped at the location, there were several contractors on site painting and cleaning the interior and exterior, providing general maintenance to the building. The lead contractor indicated they had been working at that location for several weeks, refurbishing the building, and that respondent had vacated the building several weeks to 2 months earlier. The establishment name had been covered up and removed from the location. When calling the location's business phone, it was still active and answered by the owner, but the owner only stated hello and did not answer with the name of the establishment. The inspector inquired as to the status of the establishment, and the owner stated they had ceased operations at that location and vacated several weeks earlier, and that a new location was in the process of being finalized. The owner stated that they are not taking death calls and are referring families to other funeral establishments during the transitory time. Respondent indicated that the necessary documentation would be ready for a change of location application. However, the website for respondent establishment remained active, listing the address as the old location. A subsequent call was made on May 1st, 2026, and again the owner answered with hello, but did not use the establishment name. Respondent stated that their lease at the old location was ending and did not wish to renew their lease, so they vacated the property in full on March 15th, 2026. Respondent stated on March 13th, 2026, they called the website developers for a notice to be added to the respondent's homepage. Respondent stated they were under the impression this had been completed, but it had not been. Respondent stated at the time of the response, May 18th, it had been updated. Respondent stated all business had ceased and they began referring all families to other funeral establishments. Respondent confirmed they had intentionally answered the phone hello without providing the respondent's establishment name to prevent the impression that they were operating without a fixed place of business. Respondent stated when asked, they would inform families that they were moving locations and that business operations had ceased until a new location had been approved. Respondent attached a letter from another funeral establishment confirming that respondent had been referring families to them during this time. Respondent also attached a letter from the removal company confirming the last removal they had performed for respondent was on March 10th, 2026. In reviewing this complaint, legal's concern does not come from the fixed place of business rule. Based on the evidence provided by respondent, it does not appear that respondent conducted business during this transitory period between locations. However, the concern to legal appears to be whether there is a violation of Rule 0660-11-.051I, which states, a licensee or registrant shall not engage in any conduct that may mislead or deceive the public as to the physical location of any funeral establishment. The timeline appears to be as follows. March 13th, 2026, in anticipation of the move of location, respondent asked the website developers to add a notice to the website. It is not clear what this notice would have stated specifically, but complainant admits that this was not completed. March 15th, 2026, respondent vacates the location. April 29, 2026, the inspector observed the old location with signage that was covered and removed, When calling the establishment's phone number, the owner answered with hello rather than the establishment name, further suggesting they were not conducting business. May 1st, 2026, an additional call was made where respondent again answered hello without the establishment name. May 5th, 2026, the complaint was administratively opened, showing that the notice for the website still had not been posted publicly, indicating that the establishment was still open at the previous location. May 18th, 2026, respondent indicates in their formal reply that the notice has now been provided to the website. July 1st, 2026, during the course of this report, legal went to respondent's website where the notice is still posted. The notice on the website at the heading of the website states, quote, "Due to respondent establishment moving locations, we are unable to conduct any new business at this time," end quote. Scrolling down further on the website still provides the old address of the location. Though the notice is present, the old outdated address is also still present. Likewise, a Google search of the establishment still provides the old outdated address. Based on the above, though coupled with a notice at the top of the website indicating respondents is moving locations, the old address is still on respondent's website. It could be unclear to a consumer whether the website currently posted on respondent, whether the address currently posted on a respondent's website is the new or old address, leading to confusion as to respondent's physical location. Likewise, a Google search of respondent establishment would lead a consumer to the erroneous conclusion that respondent's physical location is still tied to the old address. Furthermore, at the very least, the initial notice posted indicating that respondent establishment was moving locations had not been posted until sometime between May 5th, 2026 and May 18th, 2026, which represents anywhere from 6 to 8 weeks without any notification that the listed physical address of respondent establishment was no longer the physical address of respondent establishment. Based on the above, we'd recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
Board members, you heard the complaint. Any questions?
Mr. Bryant, just real quick, are they still licensed under the old address or have they applied for a new location or anything at this time? Or are they just kind of idling?
At this time, they have moved locations and are in the process of its sufficiency being determined. But they have signed a lease for a new location and are taking the steps to get up and running again.
Thank you.
So I guess, Mr. Bryant, my question is, so when you have an establishment that has moved from one physical address but has not gotten into the other physical address, is their establishment license still active?
It's a tricky question in reading the rule that applies. The way I would interpret it, and I would say this is up for the board's ultimate interpretation, is that they do still have an active establishment license. The establishment license is a property right that they retain, but it was linked to that fixed place of business. If you do not have a fixed place of business, I do think the rule is very clear that you cannot operate. So while you do have an establishment license, if you're in the in-between of locations, you cannot operate with that establishment license. So I guess the short version of that is you don't lose that license, you don't lose the property right, but you lose the ability to do anything with that license while you're waiting for a new location.
I guess my next question would be, so what stops them from doing something since they have an establishment license?
Again, it would be the fixed place of business rule that in this situation, in the interim, they closed location A, they're in the process of finding a new one, but they're going to go ahead and take some calls during then. That's a violation of the fixed place of business because it specifically says a funeral establishment shall not operate. And if you're operating, accepting calls, doing anything, and even meeting with families, that's in essence operating. So that would be the violation that would trigger.
So you just triggered my next question. Have they been doing any business during this time? Has the inspector found they've been doing any pre-need or any type of active at-call business?
From what we can see, no. And in the two locations where they were called by our inspectors, where they did not know it was the inspectors calling, they did answer hello. They didn't say this is Troy Bryant Funeral Home, indicating that they were open for business. They did attach in their response 2 letters, one from a funeral home saying, yes, we've been getting referrals from them since March when they closed up, from a removal company as well, saying we haven't done a removal for them since March 10th. So there is no evidence I'm aware of that they, in the interim of locations, that they've been operating.
Okay, thank you.
He answered most of my questions, but I've got 2 follow-ups. So, my assumption is that this new location they are working on will have to be approved. Because they'll have to change, change the location on their license, correct?
Essentially, so yeah, that they have some administrative hoops to jump through on that.
And it seems to me that so in an effort to prevent any unlicensed activity, not unlicensed activity, any activity where that since they're don't technically have a fixed place of business, is in our purview or in our authority to temporarily suspend that establishment license until they have reestablished a fixed facility, place of business.
I think it gets tricky when you're approaching the territory of suspending a property right for, I guess, no violation. That I think it would it technically be possible within the board's power? Maybe I would need to look into that to be sure.
If the establishment license requires that you have a fixed place of business, then they are in violation.
It requires that you not operate without a fixed place of
Right,
business.
right.
So the key phrase there is operation. That if I shut down and I do not take a single call while I'm looking for a new location, I have not violated, in my interpretation, I have not violated the fixed place of business rule.
Okay. And so can we, I guess, so in a change of location and with licensure, is there any kind of set time frame parameters? I know there's nothing in the statute, I don't think that says that, but is there, I mean, we just have people just out there with an establishment license, just, hey, we have this license and someday we'll have a building, it could be another year, we don't know. And a lot can happen in those time periods.
Sure. I think it comes back to from the fixed place of business rule, the way that language is. You have the license. It's once a license is granted, it's a property right, which gets a higher level of protection. They're difficult to revoke or suspend or strip away, but you're in this awkward position where you have it, but if you don't have a fixed place of business, you can't do anything with it without violating the rule.
So I have no issue with the penalty, but could we add I guess it'd be a letter of instruction reminding them what the statute states about that, so they are reminded of that.
Sure.
Because I think that they probably need a reminder. I mean, this has gone on now for, 4 months. As of 4 months yesterday. Essentially, it could have been going longer than that. It seems like a long time. I don't, obviously it's our job to regulate establishments, but also I think to prevent someone from any activity that's, any unlicensed or any, inappropriate activity. So I don't know. I just feel like we can give them penalties all day long, but that doesn't really, I think that I would like to make a motion to accept the penalty and add a letter of instruction on what the requirements are for an establishment license to ensure that the licensee is aware of those things. Something to that effect. However you want to word the letter of instruction is fine. I just think they need to be reminded of that, especially with the time frame that's going on.
And I have one more. When was their establishment license issued originally?
From my recollection, I believe 2024.
So they were licensed in 2024 and they've been before this board. This is the fourth time with
Correct.
violations, and I'm sort of, I lean toward what he was saying, that I guess my question is, and I guess I need legal guidance on this, is if you have an establishment license, it's like what he said, how long can you go that you're just in limbo? And is there something that this board should look at in putting that once you get a establishment license, you have a certain time frame that you must establish that permanent address?
Yeah. So again, I think it just, again, and this is my interpretation. I will say that upon the board's own reflection of the rules, if there's a If you all feel the rules suggest something differently, it's certainly within the board's purview to interpret the rules that we have on file. But from my understanding is that currently in rule and statute, there is nothing within a time frame that says if you lose your fixed place of business, you have to have a new one within X amount of days. To my knowledge, there's nothing like that. The catch-all is kind of what I was saying earlier, that it puts you in a position to where if you don't have a fixed place of business, it's not by itself a violation. But if you're operating, if you're conducting business in any way, shape, form, that immediately triggers a violation of the fixed place of business rule. So it puts you in a situation where you don't lose your establishment license, but until you get that fixed place of business, there's not a single thing you can legally do with it. And admittedly, that's a bit of an awkward position, but that's without a specific time frame of if you lack a fixed place of business, that to me, for when I read the rules and statutes, that's the, I guess, enforcing factor.
So, but I guess my issue with is that they can tell us this all along, but that doesn't mean that they're not still doing things. I mean, I just don't, I have a hard time believing that, especially with they've had a license barely 2 years. They've already hit, this is fourth time. And this, I mean, all of and the previous issues have been relatively serious. I have issue with that. And then when the other thing would be when they're going to renew their establishment license. So if they were licensed initially in 2024, unless they've already renewed it, they would be up for renewal in the last month or so.
I guess in a roundabout way, that's the time frame, right? That if they reapply but don't have a fixed place of business, then that's at the very least that wouldn't be an administrative approval.
Can you tell us when their most recent establishment license renewal was?
I'll look, but let's look again. I think they were probably actually issued the license in 2025, and I don't think the renewal was till 2027, if I remember correctly, but let Mr. Bohannon and I look again.
And one last question for legal. How did you come up with the $500 civil penalty?
Yeah, so I think this is one where, and again, I can understand if the board is more skeptical of it than I am, but based on the evidence we have, we do not have evidence that they operated during this time. I would say we have a decent amount of evidence to suggest that they did not, and painstakingly took the steps to do that. It felt like a situation about the misrepresenting the physical address. They kind of just couldn't get out of their own way. They, according to what they said, they reached out to get a notice posted. It didn't. It eventually did about 6 to 8 weeks after. So while the misrepresentation of a physical location is still a serious violation, I would say it's somewhat less serious than operating without a fixed place of business. So that was the reason for the $500 recommendation.
Thank you.
I will say this. I do appreciate that once the inspector inquired, that they were honest about, they vacated the lease, the property on March the 15th. So I can appreciate the fact that they're honest about that. But I just feel like they're gonna be before the board again with another issue if we don't do something. And I don't want to. I can understand as a business owner the things that have to be put in place to if you have an issue with where you're at or what your property you're leasing, but on the end of the day, I mean, it's our job to make sure that they're in compliance.
They were first licensed in 2023, and their license doesn't expire till 2027.
Okay, thank you.
September 30th, 2020. September 30th, 2027.
So that's my other issue would be that with that, and I guess I'm sorry I'm talking so much, but that essentially they could have this license until then active, and we just sit here and we don't have a place of business, but we're not doing any business. We don't have a place of business, and we just assume we just believe everything that they're telling us. I have some reservations about that. Obviously, I would like to make a motion to increase the civil penalty to $1,000 and provide a letter of instruction to the licensee about the requirements for an establishment, that a fixed place of business is a requirement to operate an establishment, to ensure that they understand those things. And I hope that the increase in penalty will maybe get their attention that they need to make progress with this situation. So that's my motion. If I need to restate it, let me know. Restate it, excuse me. Restate. Wow, that's not a legal term, guys.
Board members, you all heard Mr. Nash, motion to increase the penalty to $1,000 along with the letter of instruction.
Second.
Motion, all those in favor?
Aye.
Opposed, as same.
No.
Roll call.
Tim Wheeler,
Aye.
Don Haynes, Tracy Allen, Randy Nash,
Aye.
Chris Lee,
No.
Wendell Naylor,
No.
that is, Mr. President, 3 yes and 3 no. The motion doesn't pass.
Correct. The motion failed on 3-3.
If I can, is it proper now the motion's off the floor?
Sure.
I definitely understand where Mr. Nash is coming from and the history they've got since they've been open. But the way I'm reading this is they have not committed a violation. We're kind of preempting that maybe they are. And if they had maybe suspended their website, probably wouldn't even be in this predicament now.
I would say that they have committed a violation for misleading of the physical address of
Because
the
of
location.
that.
Correct.
But if they had maybe taken that step and suspended their website or took it offline, that probably would have saved them.
I think that would have assisted them and maybe, okay, at the, a little more context to provide that did not want to provide to try and keep, I guess, within the confines of the complaint. I am aware that as far as the administrative hoops for this respondent to jump through to get a new place of business, they have signed a lease. That application is in. They do have they've got a location that has not been approved at this point, but they are essentially waiting to cross the administrative finish line, so to speak. So I apologize if I imply that they're still kind of just out in limbo without any location.
I have no issue with the recommendation. I do think that the letter of instruction needs to be added to it. So if everyone's okay with that in the letter of instruction, I would make that motion, leave the violation, the penalty as is, but I do think we need to make sure the letter of instruction is there just to ensure that everything is filed, just done properly.
And just to make it clearer to the board, this website has remained up at all times. It never has come down at all. It has remained active, correct?
That's my understanding as of July 1st. I've not checked since then. That notice went up to indicate that they are no longer open sometime between May 5th, May 18th. But as far as I'm aware, that website has remained up the entire time.
So in essence, they sort of continue to mislead the public, even though they put a notice. Not all the public might see that notice. I think the simplest thing would have been just take the website down. It's no longer up. We're no longer doing business, period. So I guess my thought is, why would you leave something up if you're not doing business unless you wish to make the public feel you are doing business? You know, that'd be like, I own Wheeler Burger Stand, but I go out of business, but I've got a website up, or Wheeler Burger Restaurant, whatever, but I leave it up. I'm still misleading the public that I'm still in business where I'm not. And that's why I agree with Mr. Nash. There is that violation. And even though you put a notice, you're not accepting any new business, doesn't mean you're not in business. I guess is what I'm thinking. And so there's where my issue lies.
Mr. Brunt, do the board have authorization to have them take the website down? Until,
Sorry, that could be made a condition of the consent order that until whatever civil penalty, letter of warning, letter of caution or instruction, as well as a term that until a new place of business is, fixed place of business is retained and approved, then the website comes down.
I would agree with that.
And that also prevents any future violations.
Yeah,
Yes.
and I liked what you said, letter of caution. I think that's a little. You're throwing a new term at me there tonight. I'll run with that now. Yeah, so I'm gonna redo my motion. That's okay with everybody. I make a motion, we keep the civil penalties $500. We, in the consent order, we require that the website is taken down until the establishment comes forward with has a new location approved and a letter of instruction or caution, however you want to word it, as far as the requirements for an establishment license and the fixed place of business.
Board members, you heard the motion, Mr. Nash, to keep the penalty as $500. And in the consent order that we instruct them to take their website down, along with the letter of caution.
Second.
It's been moved in motion. All those in favor?
Ah,
Opposed, have the same. Okay, it's been moved and properly seconded that we will keep the penalty at 500. In the consent order, we'll have instruct them to take their website down along with the letter of caution. Moved by, motion by Mr. Nash, and it was seconded by Mr. Wheeler. Number 4.
Number 4, complaint number 2026-037-981. This case was administratively opened following a routine inspection conducted on May 27th, 2026. During the course of this routine inspection, the inspector observed the following. Respondent's website advertised direct cremation for $1,050. However, the advertisement did not include the required itemized listing of the services and merchandise included in that price. Respondents stated they were not aware of the requirement to itemize prices when mentioning a package, and that once they were made aware during the inspection on May 27th, 2026, they immediately corrected the issue the same day. Respondent acknowledged that ignorance of the law was not an excuse, but stated that this would not happen again. Based on the above, we'd recommend a letter of warning.
Board members, you heard the complaint. Any questions?
Motion to accept legal counsel.
second.
Motion by Mr. Wheeler, second by Mr. Levy. All those in favor, sign of aye.
Aye.
Opposed, have the same. Motion carried. Number 5.
Number 5, complaint number 2026-039-741. Actually, 1 second on this one. I don't think that complaint number is right. Okay. Mr. Gribble got me back on track. So the complaint number is correct. This is in tandem with number 6, which we'll get to following this one. Okay, so complaint number 2026-039-741. Complainant, not a relative of the decedent, alleged that respondent violated multiple statutes in regards to providing services for a decedent, fraudulently filing a death certificate, and other various issues. Complainant's allegations included the following. 1, the death certificate listed name and address of respondent as the funeral home. Respondent is not a licensed funeral establishment. Complainant cited Tennessee Code annotated 62-5-301A. Though this appears to be a typo, it's likely complainant intended to cite 62-5-309B for unlicensed activity of a funeral establishment. Allegation 2, funeral director listed on the death certificate was unlicensed individual who worked for the respondent establishment. This individual is the respondent in the subsequent complaint, citing Tennessee Code Annotated Section 62-5-301A, though again, this appears to be a typo, most likely meant 62-5-309A, for unlicensed activity of a funeral director. Allegation 3, funeral director license number listed on the death certificate was, quote, 0000000, which was an invalid funeral director's license, again, due to the fact that the individual was not a funeral director, citing 62-5-301A, though most likely meant 62-5-309A. Allegation 4, complainant stated the Tennessee death certificate must be filed within 5 days after death, and the Tennessee death certificate was not filed until August 23rd, 2024, exceeding the statutory 5-day requirement. The decedent passed away on August 12th, 2024, citing Tennessee Code Annotated Section 68-3-502A. Complainant theorized that respondent was primarily or solely responsible for this delay, as the decedent passed away while in a hospital under medical care, then thus, quote, the medical certification cause of death was likely completed by the attending physician within 48 hours as required. We have no reason to believe the physician's portion was in error, end quote. Allegation 5, burial of the decedent occurred prior to the death certificate and burial transit permit being filed, citing Tennessee Code Annotated Section 68-3-105. And finally, allegation 6, complainant questioned why the niece of the decedent was listed as the informant and not the wife of the decedent. Respondent replied, stating that respondent is a nonprofit organization, 501c3, and is officially registered as such with the state of Tennessee. Respondent attached a copy of their active nonprofit status as a religious and community-based organization. Respondent stated they provided nonprofit services to community members. Respondent purported that according to Tennessee law, nonprofit organizations are permitted to operate cemeteries and offer funeral services to their members, provided all burial conditions are met. Respondent further stated that they had previously registered with Tennessee Vital Records Department in order to access verism, and provided that their funeral director license number was 0000000 due to this arrangement with Vital Records. Respondent explained that their services are conducted according to Islamic principles, and that once a decedent is released into their care, burial is arranged promptly at the cemetery in order to abide by religious custom. And in this case, the decedent was buried the same day. Respondent indicated that they do not charge for burial services and that only the cost of materials and equipment may apply, and if the decedent's family is unable to pay, the fees are waived. Respondent indicated that the decedent's family ultimately obtained the death certificate, the certified death certificate. This case was sent for investigation. Complainant largely reiterated the concerns and claims they had made through their numerous filings. While speaking with the investigator, the president for the board of directors for respondent, who again is the respondent in the subsequent complaint, stated that he completes most of the funeral arrangements for respondent and reiterated that they were a nonprofit 501c3 religious and community-based organization. They stated that it was their understanding that based on the nonprofit status, respondent is able to conduct funeral services for its members and families. Respondent further explained that Vital Records had given them access to verism to enable them to file death certificates, and they had specifically been given funeral director license number 0000000, as that field is a requirement to submit death certificates. However, respondent stated that on or about June 20th, 2025, the verism system changed. We're now only permitted Tennessee licensed funeral establishments to enter death certificate information into verism, and that they are now unable to individually enter death certificates into verism. Respondent provided that burial of the decedent takes place as soon as possible after death and oftentimes the same day. The president explained that the body is taken from the place of death, transported by John's vehicle to the center, taken to a building located on cemetery grounds. In the building is a washing room equipped with all materials and supplies needed for washing and preparing the body for burial. He further explained that no embalming is ever performed, and the body is washed, wrapped in white clothes, and placed in a black disaster pouch, and family members are allowed to pass by the deceased and view the deceased in the washing room. The president stated that if a deceased burial is delayed for a period of time due to the medical examiner's request or any other reason, the body is then transported to a local funeral home and placed in refrigeration until the service. In this instance, the decedent died on August 12, 2024, and was transferred to respondent the following day, where the service occurred at 3 p.m. In this instance, respondent indicated that the family of the decedent had paid respondent $3,500 for the services. The investigator obtained a copy of the check and the funeral file, which further indicated the cost of $3,500 and provided that it had been paid for by check. So, taking complainant's allegations one at a time. Under 1, the death certificate listed the name and address of respondent as the funeral home, legally separately confirmed with the vital records that at the time of the decedent's death in August of 2024, respondent was permitted to submit death certificates via Verism. Although that policy changed in June of 2025, at the relevant time, respondent does not appear to have been committing fraud or otherwise falsifying the death certificate. Allegation 2, the funeral director listed on the death certificate was an unlicensed individual who worked for the respondent establishment. The same logic as above, as the president was approved to enter death certificates via Verism based on the agreement with the Vital Records Department at that time. They do not appear to have been committing fraud or otherwise falsifying the death certificate. Allegation 3, funeral director number listed on the death certificate was 00000, which was an invalid funeral director's license. Again, see above, based on the agreement with the Vital Records Department, this was a approved funeral director number since that is a required field to enter into the death certificate. 4, complainant stated the death certificate must be filed within 5 days after death, and the death certificate was not filed until August 23rd, 2024, exceeding the statutory 5-day requirement. The decedent had died on August 12th, 2024, which again exceeded the 5-day requirement and 11-day delay. The statute that complainant points to as having been violated is in Title 68, and that is within the Department of Health's jurisdiction and not within this board's jurisdiction. However, a delay in the submission of a death certificate can be indicative of unprofessional conduct. Notably, the 5-day limit that is in statute is in a statute that the board does not have authority to enforce. However, Rule 0660-11-.05F states the following: a funeral director, embalmer, or establishment shall not unreasonably delay the filing of a certificate of death. Here, there is a 10-day delay between the decedent's death and certification of the death certificate. While complainant theorizes that the delay was not contributed to by the physician, there is no proof in either direction as to the timeline of the death certificate certification. Thus, the question is before the board as to whether a 10-day delay is quote unquote unreasonable per the rules. Allegation 5, burial of the decedent occurred prior to the death certificate and burial transit permit being filed, citing Tennessee Code Annotated 68-3-105. Again, the cited statute is in Title 68 and is under the Department of Health jurisdiction, not within the jurisdiction of this board. The question before the board is whether this would violate Rule 0660-11-.05J, which states funeral directors, embalmers, and establishments shall conduct themselves in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. The question before the board on this allegation is whether preparing and burying the decedent the day after death prior to the filing of the death certificate, quote, offends the reasonable sensibilities of the public and reflects respect for dead human bodies. And allegation 6, complainant questioned why the niece of the decedent was listed as the informant and not the wife of the decedent. As the board knows, the informant is not always the next of kin. There is nothing in this allegation that gives legal concern that any statutes or rules were violated, particularly when no family member has come forward and expressed any grievance with respondent's actions. Although it is legal's opinion that based on confirmation by the Vital Records Department that respondent did not commit unlicensed activity in relation to submission of the death certificate, the question remains as to whether unlicensed activity occurred due to the funeral services provided for the decedent. Respondent indicates they are a registered 501c3 religious organization. However, that is not what the statute specifically states. The exemption statute relied upon by respondent is 62-5-102, which states, nothing in this chapter shall be constituted to prevent or interfere with the ceremonies, customs, religious rites, or religion of any people, denomination, or sect, to prevent or interfere with any religious denomination, sect, or any body composed of persons of a denomination, or to prevent or interfere with any church or synagogue from having its committee or committees prepare human bodies for the burial, or to the families, friends, or neighbors of deceased persons who prepare and bury their dead without charge. Emphasis added to without charge. The key appears to be that for respondent to act as a funeral establishment without appropriate licensure is that such services be provided without charge. The evidence obtained by the investigator and provided directly by respondent was that the family of the decedent was charged $3,500 for the services provided. Having charged for the underlying services, the 102 exemption does not apply, and this would be considered unlicensed activity under 62-5-309B. So based on the above and all of that, we would recommend a $1,000 civil penalty plus the cost of plus the cost of investigation, authorized via consent order and formal hearing if necessary.
Board members, you heard the complaint. Any questions?
Mr. Bryant, just one. Means that they're not licensed. What kind of teeth, I guess, does this fine have, and what can we do if they don't pay it? I mean, there's nothing, I know we've had this come up before when they're not regulated by us license wise. If they don't accept the penalty, is there any further steps?
Yes. So I think 102 is pretty clear that it occur without charge. I think we have, I won't even say sufficient. Black and white, in their affidavit, they say that the family was charged $3,500 and they gave our investigator a copy of that check. If they refuse to pay the outstanding order, we have a couple of options. We take them to a formal hearing where we can potentially get a judgment that they would be required to pay. I know the board has experienced a formal hearing, and at times the administrative hoops that can be to jump through. But once that order is issued, then they're required to pay it. If in the future they ever sought to obtain licensure, then this would be on their record. And if it's something they haven't paid, that license application can just be denied on the basis that there's an outstanding case in controversy that hasn't been addressed. Likewise, in the statutory scheme, don't remember the exact statute off the top of my head, but can also be the board can decide to refer for criminal prosecution as well. A violation of anything in 62-5, which is within the board's jurisdiction and purview, can be seen as a Class C misdemeanor as well. So obviously that's a few steps down the road, but the board does have options if they just say, no, we're not going to sign this.
And outside of a anonymous or citizen complaint, we really wouldn't know in the future because they're not inspected or anything like that, I guess, correct?
Yeah, we don't send I guess since they're not licensed with our department, we don't do the routine inspections. One thing I will say, the next complaint is the president is the individual, and he communicated to our investigator that they are either in the process of enrolling or have already enrolled one or two of their employees to become licensed funeral directors. So that it seems like, I won't speak for them because things can change, but it seems like their intent here is to do things the correct way.
Thank you.
So the complainant, they're obviously a very detailed person, thank you for what have you done for this one too, because I know it's a lot of work on your part. So I don't really see an issue, anything that obviously the charging, the part in Title 62 and they charge for it, I understand all that. But the complainant is really just, I feel like I don't feel like anything was, something's upset them and has brought this on. Did they give was there any indication of anything that happened during this? Was there, anything besides everything they've listed? I feel like they've got upset about something and they've just kind of.
Yeah, I will say a little bit of an awkward question. I don't know how much the complainant wishes me to share publicly on the record.
Sure.
I will just say that there is more, I guess, context here as
That's
to.
what I figured. Sure. And my last question was, I don't want to call it a savage, but this nonprofit, they didn't deny about the charge.
They
correct?
did not. No.
I make a motion to approve recommendation.
I've got just one question real
Sorry.
quick before we do the motion. So they're a 501c3. So if we issue a judgment against them and they don't pay it, would this jeopardize their 501c3 status?
It certainly could. I'm not 100% certain with all the ins and outs of how those certifications work. It would not be helpful to their certification. I can say
Okay.
that pretty certainly.
Thank you. And I make the second to Mr. Nash's motion.
It's been moved by Mr. Nash and second by Mr. Wheeler to accept council recommendation. All those in favor?
Aye.
Opposed, have the same. Recommendation is approved by the board. Number 6,
Number 6 is complaint number 2025035541. Respondent is the president of the board of directors from the previous complaint. Similarly, because the 102 exemption does not apply to the unlicensed center, respondent likewise committed unlicensed activity, though it appears to have been that respondent believed in good faith that their 501c3 certification was sufficient for purposes of the statute. During the course of the interview with the investigator, respondent indicated they were in the process of enrolling or had already enrolled either one or two individuals of their staff into mortuary school to proceed with having a licensed funeral director on staff. So based on the above, we would recommend a letter of warning regarding the 62-5-102 exemption and that subsequent unlicensed activity when said exemption does not apply.
board members, you heard the complaint. Kind of good. Any questions?
Motion to accept council's recommendation.
Second.
Motion by Mr. Lee, second by Mr. Nash. Mr. Haynes? Mr. Haynes, second. All those in favor, sign of aye.
Aye.
Opposed, have the same. Motion carried.
Mr. Bryant, just before you go, maybe it's my ignorance. I didn't realize that Prism was even open or would register non-funeral home or non-licensed. I guess I missed.
And no, I would say you're correct. In speaking with Vital Records, they said that because of the 501c3 nature of this center, it was just a kind of exclusive, just to assist them in doing their part of it, and that ultimately that they revisited that approach in the summer of 2025 and decided ultimately to stop that. But my understanding is that you're exactly correct and that this was a very unique one-off situation. Next complaint is complaint number 2026014681. Complainant and attorney on behalf of the family indicated that the decedent had paid for a funeral with respondent on July 31st, 2023 in the amount of $10,308.08. However, upon the passing of the decedent, when the son went to the respondent establishment to schedule the funeral on June 24th, 2025, respondent was required to pay for the service again, despite having brought a receipt from the initial transaction in 2023. Respondent paid for, complainant, the family member of the decedent paid $14,052 and was told to return with a copy of the canceled check for the 2023 funeral receipt and that they would reimburse for the purchase made in 2025. Complainant attached a copy of the receipt. Specifically, the receipt states respondent establishment's name at the time with their address and contact information. In the top right corner, it states, quote, pre-need funeral expenses receipt in the amount of $10,308.08. States the name of the decedent and states, quote, to be applied toward the pre-need funeral expense count of decedent's name, paid in full, end quote. This receipt is dated July 31st, 2023. Respondent replied also through counsel stating that a former employee who was fired for cause was the funeral director and manager of respondent establishment in 2023 when the receipt was dated, and that the employee was also the funeral director and manager on June 24th, 2025, when complainant alleged that the decedent's son was required to pay $14,052, and that the prior payment of $10,308.08 referenced on the 2023 receipt was not honored. Respondent stated when presented with the receipt, they began investigating and were, quote, unable to locate any payment that was deposited into any of its accounts related to the 2023 receipt or any insurance policy related to the 2023 receipt, end quote. Respondents stated they requested a copy of the canceled check or other evidence of payment related to the 2023 receipt, but that they have yet to receive any additional documentation to confirm that payment was made. Respondents stated they requested this additional information for further review and investigation so that they would be able to show who the payment was made payable to, the account it was deposited into, and who endorsed the check. Leading up to the May board meeting, legal asked the complainant and respondents counsel to coordinate together to discover if additional documentation regarding the transaction exists. During this communication, complainant indicated they no longer represented the family and would be withdrawing. When legal explained that this was not the more formal process of court where you could enter a notice of appeal or withdraw at virtually any time, that complainant was the complainant by virtue of filing the complaint. Complainant seemed reluctantly willing to continue pursuing the complaint. Respondents' counsel submitted a letter to legal dated June 19th, 2026, stating they had provided complainant a letter dated May 11th, 2026, explaining the additional documentation they were asking to receive, an offer to speak further and coordinate, and requested a response within 10 days. During the approximately 5 weeks that had passed, complainant had not responded to respondent's request or letter. In fact, respondent indicated that complainant had not contacted them in any manner since filing the complaint. Legal had asked complainant on multiple occasions to work with respondent and to report back on the fruitfulness or lack thereof of those meetings. Complainant provided no contact information whatsoever for the family they once stated they represented, leaving legal no avenue to reach out to the family directly. It is clear to legal, as complainant indicated in our conversation in May, that complainant is no longer interested in proceeding with their complaint. Based on the above, we'd recommend closure with a custom closure letter to complainant indicating that the family is welcome to file a complaint if they still feel a violation has occurred.
Board members, you heard the complaint and legal recommendation. Any questions?
Motion to accept council's recommendation.
Second.
Motion by Mr. Lee, second by Dr. Allen. All those in favor?
Aye.
Opposed, have the same. Motion carried. Number 8.
Number 8 is complaint number 2026-021761. Complainant, the owner of cemeteries within the area of respondent establishment, alleged that respondent had, quote, repeatedly conducted unauthorized memorial installations, end quote, at the cemeteries despite being instructed to stop. Complainant stated that respondent was bypassing required cemetery procedures, quote, including authorization and collection of installation fees, end quote, and also introduced compliance concerns regarding oversight, record keeping, and financial accountability. Complainant stated that respondent had demonstrated unprofessional and disruptive conduct towards staff and vendors, and provided that an internal review had already identified 2 unauthorized bronze marker installations in February of 2026. Complainant attached 2 blank interment authorization forms, presumably to show that authorization had not been given, the 2 contracts for the bronze markers signed by the family, and photographs of the 2 markers. Respondent indicated that there were further findings pending and, quote, we will continue our examination and provide supplemental documentation as additional findings are confirmed, end quote. However, to date, complainant has provided no additional documentation. Respondent replied, stating that first, regarding the allegation of being unprofessional and disruptive, respondent purported to attach a phone call from complainant that would show the unprofessional conduct stemmed from complainant. However, respondent did not attach this phone conversation, but purported that complainant, quote, immediately accused us of stealing, and then indicates that their denial was a lie while calling them and their staff childish. Respondent states their allegation is a reflection of their own poor service and that they work with cemeteries throughout the state. They're the only cemetery management group, quote, that acts like this on a consistent basis. Respondents say they had never performed unauthorized installation of markers at either cemetery and did not fail to follow their cemetery procedures regarding 1 marker delivered to the cemetery office on May 28, 2025. According to an employee of respondent, the granite base was already installed and were only waiting on the bronze screenshot. Respondent attached screenshots to show they had coordinated with the employee, who is no longer employed at the cemetery, to drop it off. On November 5th, 2025, the respondent was contacted by the family asking about the marker because it had yet to be installed, and the cemetery claimed they could not find the marker they had dropped off. So respondent ordered a replacement and received it in February of 2026 and took the marker to complainant's office. The new employee informed respondent they would need to pay an installation fee, but that respondent staff informed them they would have to call the family as they had not charged an installation fee because the VA marker was free. However, when respondent spoke to the family, they indicated the VA marker was already set, so they brought the marker to the warehouse. Respondent states that complainant's claim is that they went and installed the marker themselves. However, respondent indicated they still have the marker in their possession and that the contract presented by complainant has no date signatures or any other information that would link it to respondent. Respondent's assumption is that someone at the cemetery added the marker to the base or that a monument company installed it, and that is indicative of a lack of documentation on complainant's end. For the second claim, the bronze marker date death scroll that was installed was picked up by the family from respondent's funeral home. Respondent stated they received the scroll on February 2nd, 2026, and spoke with the family on the 11th to let them know they would need to go to the office and pay the setting fee. Respondent stated it is highly likely the family went and added the date of death themselves, but provided specifically that respondent was not in possession of the date of death after February 11th. Again, respondent indicated the provided contract had no documentation or information other than the name and did not indicate that respondent had agreed to pay and that no one at respondent establishment was aware of the contract and it had never been presented to them. Based on the above, complaint does not provide sufficient proof to show that respondent violated applicable laws or rules. Therefore, we would recommend closure.
Board members, you heard the complaint and council recommendation. Any questions?
Motion to accept.
Second.
Motion by Mr. Lee, second by Mr. Nash. All those in favor, aye. Opposed, have the same. Motion carried. Number 9.
Number 9 is complaint number 2026024251. Complainant, fiance of the decedent, made several allegations of violations against respondent establishment. Specifically, complainant stated the following. 1, respondent pressed complainant to make arrangements the day after the decedent's death while under emotional pressure. 2, respondent failed to provide a general price list at any time during the process. 3, respondent overcharged as the veteran's full cremation package was $3,495, while the final bill was $6,003.95. Respondent stated added charges included $695 for the use of facilities and staff for viewing and visitation, $695 VFC weekend. Complainant states they were not informed of this additional charge. Service fee, $495 transfer of remains, $25 cremation, $75 certified death certificates, and $285.90 of express funeral. 4, indicated burial on the cemetery requirement designation and provided that the decedent was cremated, not buried. 5, improperly applied services from the decedent's mother's services onto these arrangements. Complainant explained that the decedent's mother died on September 13th, 2021, and that charges from the mother's burial had been applied to the decedent's because they, quote, matched the exact same categories and amounts from his mother's burial, end quote. Complainant stated that these charges do not occur for direct cremation and that the incorrect designation of burial is further proof of this. 6, the invoice was dated November 11th, 2021, which was the date of the decedent's death, so it was impossible for the invoice to be dated that day. 7, bill for viewing and visitation and weekend service prior to receiving the body until November 19th, 2021. And 8, stated that since respondent gave legal authority to the sister and son of the decedent instead of her, the fiance, beneficiary, and executor. Respondent replied stating that these services were provided on November 19th and 20th, 2021, nearly 5 years ago. Respondent stated over the past 3.5 years, complainant had contacted their staff repeatedly, and that these communications contained threats to file complaints and pursue legal action and have risen to the point of what they would consider harassment, despite their attempts to address the concerns. Respondent stated the decedent is survived by 2 adult children who are the legal next of kin. Respondent stated both sons and complainant met with their staff to make funeral arrangements, and that they chose a full cremation service, which included a visitation, a funeral service the following day, and cremation. Respondent stated while complainant was involved in the arrangements, all documents were completed by the sons in accordance with state law and their policies. Further, respondent stated it is their policy to provide a GPL to every family member at the time arrangements are made, and that complainant initialed the contract confirming that she was given this information, and thus respondent denies that complainant was never provided a general price list. Respondent stated the charges on the invoice reflected the services selected by the family as veterans full cremation package, and that a disclaimer stated other fees may apply for additional days of visitation, weekend, or off-site. Respondent further provided that the transfer of remains was itemized separately since this is an expense the Department of Veterans Affairs typically reimburses the family, and that the cremation permit is not included within their service charges as it is a state required fee. Respondent explained that the family and complainant decided to do a night of visitation and service on a weekend, which incurred additional fees, and that the family and complainant notified them that they would be using an insurance policy that complainant was the beneficiary of, and that it was explained she was not legally required to pay for the services as she was not next of kin, but that ultimately she decided to use the insurance proceeds to cover the funeral expenses. Respondent attached a document showing complainant's signature on the contract and insurance assignment form. Respondent stated one section was mistakenly marked burial instead of cremation due to a software error, but it was explained at the time and understood that cremation services were being provided. Finally, respondent stated that complainant assisted with the obituary and attended both the visitation and funeral services, and at her request was even provided an additional United States flag during the military honors. Respondent denied that any charges for another individual services were included on this account. Complainant provided a rebuttal that purported to include a screenshot of a text conversation with an employee of respondent establishment about not providing a GPL. However, no screenshots were provided. Additionally, complainant included a copy of the decedent's last will and testament. However, after reading through the document, it appears the will identifies complainant as the financial beneficiary with the ability to make financial decisions on behalf of the decedent's financial assets following their passing. It does not identify nor assign a power of attorney to complainant to make decisions involving their disposition or assign next of kin authority to complainant. So based on the above, we would recommend closure.
Board members, you heard the complaint and legal recommendation. Any questions?
Yes. I just have a question. It's very simple. Under number 3, and this is really just for an educational purposes, Troy. Under number 3, the very last thing it says is 285-90 Express Funeral. Whose verbiage is that?
That is the complainant's.
I believe that's probably referring to Express Funeral Funding, which is a insurance funding company, since it was an insurance assignment.
Yeah, I didn't. I thought that
Would've
was
been
like
a
a
fast
joke, and I
funeral.
was not very humored by that. Okay, yeah, okay. Okay.
Is there a motion on the floor?
No, sir.
Motion to accept council recommendation.
Second.
Moved by Mr. Lee, second by Mr. Wheeler to accept council recommendation. All those in favor, sign of aye.
Aye.
Opposed, have the same. Motion's carried. Board members, I'm gonna have to recuse myself for number 10. Mr. Nash. I turn it over to you.
All right, the next complaint is complaint number 2024045761. An anonymous complainant submitted a letter and photographs indicating that respondent, who had their funeral director's license revoked in 2015, was continuing to work without valid licensure. In the letter, complainant alleged that respondent continued to work funerals despite lack of licensure, and as evidence of this activity, complainant took several screenshots of respondent's Facebook page. Most of the photographs do not provide proof of alleged unlicensed activity and are not indicative of any violations. Pictures such as a selfie of respondent stating good morning, respondent sitting at a desk writing, respondent and staff photographs for a funeral establishment in which they are employed, and photographs or posts in which respondent is tagged by individuals thanking respondent for his professionalism, but not otherwise indicating that respondent conducted funeral services. Anonymous complainant indicated more information would follow, but to date, nothing has been provided. A description of the relevant posts that suggest potential unlicensed activity are as follows. 1, a post by an individual in which respondent is tagged stating, quote, respondent, a funeral director, secured decedent's coffin in a hearse after their 90-minute funeral service, end quote. Respondent is standing next to a hearse with the door open and a casket inside it. 2, a post by a different individual tagging respondent, praising their professionalism and their dedication to help each individual. However, the picture shows respondent carrying a casket into a church for service. 3, a post by respondent in a cemetery next to 2 headstones captioned in pertinent part, quote, anytime I'm doing a funeral ceremony at this particular cemetery. And 4, another post by the first individual with a photograph of the individual and respondent next to a hearse stating, quote, funeral establishment, funeral director, respondent, a compassionate gentleman in the funeral industry. Complainant also provided screenshots showing that respondent had recently obtained continuing education credits. However, complainant made no specific reference to this information other than providing screenshots of the continuing education credit. Respondent complied, affirming that they do work at the identified funeral establishment, but that their direct report is the location manager, who in turn reports to the market director. Respondent explained in their current role they assist licensed funeral directors with services. Respondent stated, quote, "I do not act, nor do I represent myself as a licensed funeral director to anyone. My role at the funeral home is that of a funeral service team member. I have many duties, and I am supervised by a licensed funeral director in all of my interactions with our clients," end quote. Respondent further specifically brought to attention the individual who made 2 tag posts indicating respondent was a funeral director. Respondent explained this individual is a community publicist who is not employed by or affiliated with the establishment. Respondent stated they had never indicated to her that they were a funeral director, and they have attempted to correct her in relation to their specific title and duties with the establishment, quote, "but to no avail." The pertinent statute here is 62-5-1016A, which defines funeral directing as I, practice of directing or supervising funerals or the practice of preparing dead human bodies for burial by any means other than by embalming or the disposition of dead human bodies. 2I, making of arrangements to provide for services or making of financial arrangements for the rendering of funeral services. 3I, provision or maintenance of a place for the preparation, for disposition, or for the care or disposition of dead human bodies. IV, use of the word or term funeral director, undertaker, mortician, funeral parlor, funeral chapel, or any other word or term which can be implied the practice of funeral directing. Or V, holding out to the public that one is a funeral director or engaged in a practice described in this subdivision 6. Likewise, subsection 13 is relevant as it defines unlicensed assistant as follows. A, means an individual who assists in the operation of a funeral establishment under the direction and supervision of a funeral director or embalmer, and who is not a licensed funeral director or embalmer pursuant to section 62-5-303. And B, does not mean an individual who previously held a funeral director or embalmer license in this state that was revoked, suspended, or voluntarily surrendered with outstanding complaints. Based on this definition, respondent is not and cannot operate as an unlicensed assistant due to the previous revocation of respondent's funeral director's license. Again, when looking at the provided Facebook screenshot through this lens, photographs showing respondents sitting at a desk, wishing people good morning from their car, or sitting at a table at a conference are not indicative of unlicensed activity or operating as an unlicensed assistant. When looking at the 4 previously identified posts, legal would suggest the following. For one, while this individual's misunderstanding of respondent as a funeral director could arguably be evidence of respondent holding out to the public that they are a funeral director, respondent has indicated they have informed the individual of their role and communicated they are not a funeral director to no avail. However, the photograph of respondent standing behind an open hearse with a casket inside suggests respondent is operating as an unlicensed assistant in violation of the statute. The second picture shows respondent with another individual moving the casket into the chapel for a funeral service. While the poster's praise of respondent's professionalism and assistance is not necessarily evidence of respondent committing unlicensed activity or acting as an unlicensed assistant when the statute does not permit that action, the photograph does indicate that respondent was acting as an unlicensed assistant in violation of the statute. 3, respondent's post in the cemetery next to headstone stating, "Anytime I'm doing a funeral ceremony," end quote, which legal would suggest is holding out to the public that respondent is conducting funeral services as a funeral director in violation of the statute. 4, again, the individual's erroneous labeling of respondent as a funeral director could arguably be indicating that respondent has held out to the public that they were a funeral director. However, respondent has indicated they have attempted to correct this on multiple occasions to no avail, and the board does not have evidence to suggest the contrary. The photograph itself does not show unlicensed activity or evidence that respondent is acting as an unlicensed assistant, as it is just the respondent and the individual posing for a picture next to a hearse. In legal's view, this does not indicate a violation. Based on the above, it is legal's opinion that 3 out of the 4 relevant pictures suggest that respondent is either acting as an unlicensed assistant in violation of the statute or holding out to the public that respondent is a licensed funeral director when they are not. We'd recommend a $1,000 civil penalty authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any questions for legal?
One real quick, is the person listed on the establishment website, and how are they listed?
Good question. I can check that real quick.
You see that?
Mr. Wheeler, it's my belief that this establishment does not list any individuals, but Mr. Bryant's going to double check it.
Okay.
I don't think they show their staff, individual staff members or give them any titles at all, including they do not list their, I don't think they list their funeral directors either.
From my review, it appears that Mr. Gribble is correct. I don't see a location where they even list the staff.
Okay, thank you.
And with him standing by the hearse or rolling the casket in, we're considering that a violation because his license is revoked. And he's acting, I guess, outside of a helper or anything because of a revoked funeral director's license.
Yeah, so from that, it would be my interpretation of the statute that that would be operating as arguably license activity. I think that would be for the board to decide. But even if the board were to decide that's not the case, that would still be acting as an unlicensed assistant. So there are kind of levels here of whatever line the board decides when you cross that line as license activity. And then even if the board determines he did not, the respondent here didn't cross that line, whatever activity would be that of an unlicensed assistant. Because this respondent's license was revoked, the statute for unlicensed assistant specifically carves out an exception. You cannot act as an unlicensed assistant if your license has been suspended, revoked with open complaints. So I guess there are conceivably two lines he could cross, and if he crosses either of them, it would be a violation.
Any other questions?
Well, and maybe it's just a clear fog in front of me, but anyone that assists in those two specific items are required to either be licensed or a licensed assistant.
So there is no specific licensure for a licensed assistant. It's called specifically an unlicensed assistant. So if, I guess with the wealth of knowledge I've learned as the board's attorney for 5 years, if I quit this job and while I'm going to mortuary school to get a license to become a funeral director, I can assist as long as I don't cross that line of license activity, right? But I can still operate as an unlicensed assistant if I follow everything in that statute. If in this case, like we have here, an individual who used to be licensed, but now that license has been revoked, suspended with open complaints, they cannot operate as an unlicensed assistant anymore. That definition of unlicensed assistant carves out that specific occurrence when a license has been revoked.
I make a motion, we accept council's recommendation.
Second.
Motion by Mr. Wheeler, second by Dr. Allen. All in favor, signify by saying aye.
Aye.
Any opposed, like sign? All right, motion passes.
Next case.
Yes, next complaint is complaint number 2026-015801. This case was administratively open following a routine inspection conducted on March 3rd, 2026. During the course of this routine inspection, the inspector observed the following. Upon entering respondent establishment, the inspector observed two individuals, a woman, who we'll call expired apprentice, who once had a valid apprentice registration that had expired in 2023, and a previously licensed funeral director whose funeral director's license is suspended until October 2026, who we'll call suspended director, meeting with two different families and, from the inspector's observation, both serving in the capacity of a Tennessee licensed funeral director. The inspector observed the expired apprentice, quote, making funeral arrangements with one family in the front office, end quote. The inspector was unable to obtain documents from the first family that the expired apprentice was making arrangements with, as they were careful not to interfere with the arrangement conference. Additionally, the inspector observed suspended director speaking with the second family. Before finalizing the arrangements for the decedent, the suspended director left the premises, and the expired apprentice began to speak with the second family. The inspector stated the expired apprentice was sitting at a desk writing and making arrangements with a family, and situated on a desk behind the expired apprentice was a casket selection brochure. The expired apprentice then provided the family with a statement of funeral goods and services, which had the casket selection from the family listed. The statement of funeral goods and services was signed by the owner, who is a licensed funeral director. The inspector stated they spoke with the expired apprentice, who provided that the suspended director was, quote, speaking to both families until she could meet with both families to make arrangements, end quote. The inspector reiterated in their report that the expired apprentice, quote, stated that she would be making funeral arrangements with both families, end quote. The expired apprentice called the owner/funeral director, who is not at respondent establishment. The inspector stated that they spoke to the owner, funeral director, and confirmed that they were not currently present at the establishment. The owner/funeral director replied on behalf of all respondents, stating that when the inspector first entered into the respondent establishment, they began pulling information for them to use in the inspection, but that the inspector left respondent establishment to take a call, and when they returned, quote, his demeanor changed, end quote. The owner and funeral director stated they continued to be cordial, and that when the inspector asked for the owner and funeral director, the inspector was informed that he was not at the respondent establishment due to a prior engagement. Owner/funeral director stated that when the inspector saw the family in the office, they were asking about the casket they had selected earlier with owner/funeral director. Due to the owner/funeral director's prior commitment on certain Tuesdays, quote, families only come to finalize previous arrangements. The owner funeral director denied that expired apprentice ever told the inspector that she was making arrangements with the family, as those arrangements had been previously made. This case was sent for investigation. The investigator conducted a telephone interview with the son of the decedent of the second family that the inspector observed the expired apprentice meeting with. The son stated that, quote, on or about March 3rd, 2026, he and his twin brother went to respondent establishment to make funeral arrangements, end quote. When asked who they had met with to make arrangements, the son stated he could not recall the name, but remembered, quote, meeting with a woman, end quote. The inspector also reached out to the twin brother, who likewise stated that they met with, quote, an elderly woman, end quote, but could not recall her name. The brother further stated that he did not recall ever meeting with the owner/funeral director or suspended director. Although the sons of the decedent were unable to recall the name of the individual they met with, both stated they met with a woman matching the description of expired apprentice. In short, while somewhat of a he said, she said as to whether expired apprentice indicated that they were making funeral arrangements with both families, in favor of expired apprentice having made arrangements are, 1, the inspector's eyewitness of expired apprentice meeting with two families, one at a desk with casket brochures behind them. 2, the inspector also obtained the statement of funeral goods and services. Although expired apprentice stated they were not meeting with the families and that the families were going over arrangements that had already been made and executed by owner/funeral director, at the top of the statement of funeral goods and services, it is dated March 3rd, 2026, the day of the inspection. While it could have been executed earlier that day, all parties agree that owner/funeral director was not present at respondent establishment during that time. 3, the sons of the decedent both recalling that they met with a woman matching the description of expired apprentice to make arrangements with one of them, stating specifically that they did not recall meeting with expired director suspended director or owner/funeral director. Although expired apprentice denied, stating that they were making arrangements with the families and stated that owner funeral director had previously made the arrangements prior to the inspector's presence, the evidence above, at the very least, calls this into question. Based on the above, we recommend, and this is for the establishment, $1,000 civil penalty plus 1/3 the cost of investigations, authorized via consent order and formal hearing if necessary.
Board members, you heard the complaint. Any questions?
I just have one, on the statement of goods and services, did y'all get a copy of it? I guess I'm questioning, how did the owner operator sign it if he wasn't in the facility? And who signed his name?
We did get a copy of that, and yes, that is a excellent question as to how someone who all parties agree was not there signed and dated it the same day that it was there, suggesting that someone else signed that individual's name.
Thank you.
I have a question. I have two questions. One, at the beginning of the summary, it talked about a suspended director, but that individual is not the owner funeral director.
That is correct. There are 3 individuals at play with
Okay.
this complaint.
Okay, because obviously the inspector witnessed the suspended director in there with 2 families, the way this reads.
Yeah, I think at first, expired apprentice was with one, suspended director with another,
Okay.
and then suspended director got up and left, and then the
Okay.
apprentice went over to the second family.
And then my second question is, just based on past history, where this 1,000 recommendation, is that just because this is different than all the others?
So we are limited to $1,000 per day per violation. I think the board could make an inference that similar arrangements were happening with that second family. Unfortunately, we were not able to get any documentation. But that $1,000 would be the max for that. And then the subsequent complaints, the next 3 are the individuals as well.
I'm next. So this is what bothers me. What I don't like, I mean, obviously we know what happened at this time. But if you look back in 12 years, you've got 12, if you include this one, 12 complaints in 12 years. And I mean, when are we going to say enough is enough? I mean, I don't know. I mean, they've paid every penalty, which, I mean, I assume, let me rephrase that. We've given them penalties. I'm assuming they've paid all the penalties. And then they've got other penalties previously for, aiding and abetting on license, unprofessional conduct. I mean, multiple situations. When does it come into play where, why do we allow them to continue being a licensed funeral establishment in the state if they obviously continually break the rules and laws of the state, and blatantly did it in front of a inspector this time? And if it's been done this time, it's most likely been done before. Obviously, we can't do anything about those things. I just don't know. I mean, the $1,000, obviously I understand that per day. I get that, but I just have trouble. I mean, continuing letting an establishment have a license that obviously can't be in compliance. I don't know what we can do about that. I know we've done things in the past, but I have trouble with that. I'd have to say that. I'll just have to put that on the record. I don't see how we can, in 12 years, 12 complaints, and if you count the penalties, I mean, well over $10,000 in penalties, maybe close to 20, at least $10,000 to $15,000 in penalties, and we're still, here we are. And the last one was just within the last 2 years. I mean, we can $1,000 them to death, but that doesn't stop them from continuing what they're doing, obviously. And so I guess my question to you is what, I mean, when do we say this is it? You can't do this anymore? or you can't be like, we can't permit you to be to practice in this state with an establishment.
Yeah, I mean, the decision is, within the board's purview. That's in lieu of or in addition to civil penalties. You can also look at license suspension, license revocation. That's certainly within the board's purview. I will say this one I think is a little tricky in that while our inspector got there and observed, I think it's one of a case that has a lot of circumstantial evidence in it. When our investigator reached out to the family members that had met with them, there seemed to be a reluctance to assist. I think our inspector was fortunate to speak with them on the phone. So that's a little bit of why there's not a recommendation of a larger.
My assumption is that the establishment most likely reached out to those people and told them to expect this is going to happen.
It's possible.
Mr. Nash, we've done this before. How about unannounced visits with the cost for?
I don't have a problem with that.
I mean, I agree with you
I don't-
100%. $1,000 was my question, big time.
I think that's, I feel like we need that there's something besides just another civil penalty. Because they can, obviously they're paying them all day long. So, I'm trying to remember how we put that in the motion the last time we did that, but,
And-
board members, tell me if you think I'm off base here.
No, I agree with you. I want to make sure we're right. And,
Yes.
and why the third cost for the cost investigation? I mean, they caused us to have to do that. Just curious.
The other respondents later with civil penalties have the other third, the two other thirds.
Okay.
I see that now.
What can, so if we were to, require to put in that penalty that there would be unannounced inspections, what I cannot remember the last time we did that. I remember doing it. I just don't remember what we
Yes.
put into place.
Yeah, I mean, you have broad authority, I would say, for the next year, 2 years, 10 years. And then you can make those inspection costs to be paid by the establishment.
So with that, Mr. Bryant, are we allowed to put in there that the next violation can or will result in the suspension or revocation of your license?
I think it comes to when, if there's a violation in one of those inspections, right?
Yes, I think that would,
I think we can make that.
yeah, at that time, if, the board decides to do that, we send someone out there, catch violations again, it would become its own complaint, come before the board, and I would add a note of saying, hey, this is that same respondent. This was caught in those routine or unannounced inspections.
I get what Mr. Nash is saying. It's like we can fine every time we meet and they pay it. He's wanting teeth in it. He's wanting something that, can get their attention that
Sure.
This is more than just write a check and pay this fine.
All right. So I'm going to try to craft this motion. Let me make sure I'm not going to say re-say again. I want to say restate. So I make a motion that we to leave the $1,000 penalty as is, as far as, and that's also the third of the investigation cost, and that we for 12 months we will perform unannounced inspections at the cost of the establishment. Costs to be applied to the establishment, or how that needs to be worded.
I have just one question real quick. So we know an unlicensed individual weighed on the family, a suspended or whatever unlicensed funeral director evidently talked to the family. And we have pretty much the idea someone forged the owner operator's name on the statement of goods and funeral services. So is that not technically 3 violations right there, tacking on $1,000 per violation?
I think they get spread out of I guess it's how you view it of, uh, could perhaps argue that would all come under the establishment, but I think more accurately, that would be a violation of the, expired apprentice, a violation of the owner funeral director. Not to jump ahead, but the future recommendations for the expired apprentice is 1,000 plus the 1/3. And then for the owner funeral director, 750 plus the 1/3. So those are essentially, I would agree, just apportioned out to the different respondents.
No other questions.
I
Mr.
second
Na-
Mr. Nash's motion.
Okay, Mr. Nash made a motion to accept $1,000 penalty plus 1/3 cost of the investigation, and for 12 months that we do surprise inspection on the location. It's been seconded by Mr. Wheeler. All those in favor, sign aye.
Aye.
Opposed, have the same. Motion carried. Number 12.
Okay, next complaint number 2026015811. The respondent of this complaint is the owner slash funeral director from the previous complaint. Recommendation would be a $750 civil penalty plus 1/3 the cost of investigation, authorized via consent order and formal hearing if necessary.
Board, you heard the complaint, council recommendation. Any questions?
I have a question. Why the 750 and not 1,000?
Couple of reasons. One, the lack of disciplinary history. It looks like this respondent had a letter of warning back in 2009. And everyone agrees that the respondent was not there that day. The respondent of this complaint was not there. It leaves open, arguably, lesser culpability if someone is signing this individual's name without their knowledge, approval, anything to that sense. So I recommended the 750 to kind of, I guess, weave in that possibility. But if the board's determination is that, no, we think it needs to be 1,000 across the board for each of them, I have zero objection to that whatsoever.
I guess I'm wondering at what point in time would the owner become aware of the fact that his name was forged, or he knew it and went along with it?
Pre-signed. Exactly.
Pre-signed, yeah.
I'm gonna make a motion, we increase it to $1,000.
Second.
Motion on the floor from Mr. Nash that we increase penalty from $750 to $1,000, and second by Mr. Wheeler. All those in favor, sign aye.
Aye.
Opposed, have the same. Motion carried.
And just to clarify, that motion included the 1/3
I
investigatory.
apologize. Yes, sir. If you need me to put on the record, I can restate that.
Just in case, yeah.
So the motion is to increase the penalty to $1,000 plus 1/3 of cost of investigations and authorize via consent order and formal hearing if necessary.
And I second that.
Okay.
Next complaint number 2026015861. Respondent is the expired apprentice from complaint number 11. Recommendation would be $1,000 civil penalty plus 1/3 the cost of investigation, authorized via consent order and formal hearing if necessary.
Heard the complaint. Any questions?
My standard, do they have a website, and what are these employees? If they do have a website, are they listed, and what is their titles?
There is no specific listing. They do have our staff tab on their website, but just a generic staff members are carrying experienced professionals, no specific identifiers.
Thank you.
No other questions? Can I get a motion?
So moved.
Motion by Mr. Willis, second by Mr. Haynes. All those in favor?
Aye.
Opposed, have the same. Motion carried.
And next complaint is complaint number 2026015881. Respondent is the suspended director from complaint number 11. Recommendation would be a letter of warning regarding the definition of unlicensed assistant and limitation of action involving unlicensed practice.
So that's complaint 11 and not 4.
Yes, sorry, that was a previous draft.
Couldn't figure that out.
So this is the director, and he already had he or she, they already had a suspended license.
Correct. Basically, the inspector's observation of all of this is that they were speaking to, kind of like walked through with Dr. Allen earlier, speaking with one family, a expired apprentice speaking with another, suspended director gets up and leaves, and then the expired apprentice goes and speaks with that second family. And our investigator was only able to speak with that second family, not the first. And the family members state specifically, we do not recall ever meeting with, oh, go ahead, sorry.
Go ahead, you're good.
That they don't recall ever meeting or making arrangements with the suspended.
And so does this not fall back to under that, the statute about if you're your license has been revoked, suspended, or voluntarily surrendered, that you're not to work as an unlicensed assistant in a funeral home?
It does, yes. But I guess in the previous complaint where that was at issue, we had Facebook photographs that showed pretty detailed action. We're here out of the full picture of the complaint. All we have is that initial inspector's observation, which I would say crosses the line as a violation, but considering what we have and the lack of other evidence from the family members, that just would put the complaint in a difficult spot.
And so we have the previous 10 complaints on this person. And 1, 2, 3, at least 3 of them were sent to collection. And I'm guessing that this last complaint was where the license was suspended. Once again, when it's enough, and this person has a suspended license, but still continues to not do what they're supposed to do, and our inspector, regardless of what the inspector witnessed that person in that establishment doing what they're not supposed to do. And I mean, and I realize that you've got letter of warning and what you've got in it, but I mean, he can look at that letter of warning and put it in the trash.
Sure. I guess the issue is that.
I'm not being abrasive to you. I don't think that way. I'm not fussing at the
Sure.
person. I'm just,
No, I completely understand. I guess the issue is that with a suspended license, the board doesn't have a lot of leverage, right? What can we take from him if his license is already suspended? So the logic here as to why it's a letter of warning regarding that specifically is I plan on making abundantly clear in that letter that essentially what we walked through before of you can't do licensed activity. You
Yeah.
can't do unlicensed assistant activity either. And then if it becomes, it's on his record as that being a problem as well. And if it comes back, I think we're probably looking at additional suspension from there.
how long was his license, the suspension for?
A year suspension from my recollection.
And so they haven't reapplied for licensure?
Not yet. Yeah, it would.
Now, if he reapplies,
in
is
here?
that administratively approved, or would he come back to us?
I think he comes
I'd like to
back
kind
us.
of see.
Well, that was actually
Yeah.
my question was gonna be, what happens in October?
So for Okay, I think there are a couple of questions there. For the suspension, no. The terms of that consent order was that it would automatically, upon a year-long suspension, be lifted. If, while this individual is waiting for their license to be renewed, and, well, my license is suspended, I don't need to pay for that now, I'll do it later, and then they go past the expired grace period, then yes, they have to start over and come back through. My understanding as well is because the board had previous concerns about civil penalties being sent to collections and never being collected, we added language specifically that would involve, if you sign this and agree to pay it and you don't, your license is suspended until you do. So my recollection is that for a respondent to have their license unsuspended, they've got a couple of hoops to jump through. They have to wait till October and they have to pay everything they still owe. So all of that lengthy way to say, I think as of now, if respondent does not pay anything additional to those owed civil penalty amounts, once the license suspension lifts in October, they still do not have they will still have a suspended license.
So he still has monies that's owed. Is that correct?
Correct.
Do we have an amount on that?
It's like about $4,500.
I've pulled that a few times.
Has he not paid anything? I guess is my question.
My recollection is that they've paid some, but not all.
Okay, so he's $4,500 or less owing to the board or to the Board of Funeral Directors and Embalmers. And I guess the last complaint that in 24, he failed to even respond to the complaint within the specified time. So I'm detecting an attitude of, I don't care. You have no jurisdiction over me. And there's where my problem lies, along with, I think, what Mr. Nash is saying. When is enough that they just can't do this, period?
Okay.
So from what Mr. Gribble is showing me, it appears this respondent is already past their 90-day grace period. So the short version of what all that means is that if the respondent wants to become licensed, they have to A, pay the money that's outstanding, B, start over for an application, which would involve coming before this board. This board could, if they chose to do so, deny that licensure at that time. I think to attempt to answer your question of when is enough, I think this respondent has a difficult road to return to licensure. And if, oh God, I'm sorry.
Can we, so when we, obviously they'll have to come, because of the suspension, they automatically have to come before the board, be reinstated, is that correct?
No, the suspension would lift automatically, but because they are past their 90, assuming we're looking at this correctly, because they're past their 90-day licensing grace period, they would have to reapply as a funeral director.
Can we require a person when they reapply to have to take the law test again?
That could be made a term of the consent order, but I think it's just a fresh application, which would require taking and passing it anyway, if I'm understanding that correctly.
At any point, could the owner of this establishment be charged for aiding and abetting? I mean, I don't think it's gonna get his license.
That's my other question. Is that was one of my questions, but I didn't get into that. I don't. I had to have trouble that there even a remote chance that this person could be licensed again. I have an issue that the previous, that is, obviously their employer still has a license and an establishment license. And if it's suspended and it's already if it's suspended and it's out, they're already past their 90-day grace period. They technically are not licensed now. Is that my understanding? They're unlicensed.
Yes.
So there's nothing we can do. Can we prevent them from reapplying for licensure?
I don't think you can prevent them from reapplying, but you can deny.
So obviously civil penalties are gonna make a difference because they're not paying them anyways. So I think that I'm gonna craft a motion. Then you tell me if I'm off base. So with a letter of warning, yes, but then requiring complete reapplication for licensure, including but not limited to law test and mandatory appearance for the board.
I guess you don't have to carve that in. That's something they would have to do anyway.
Okay.
And they may decide juice is not worth the squeeze. I'm done. I'm not applying any. I'm out. But that all of those hoops they would need to jump through anyway.
And so then we go back to, there's probably still gonna be employed at this establishment. Most likely.
And that's where my issue lies. We have an owner operator that is permitting this type of behavior for unlicensed personnel to wait on families and sell funerals or, goods and services. So how does the board deal with this? Because the owner operator, we know certain Tuesdays he's not in the building because he's going to do what he wants to do. And he lets his staff present do whatever, even though he'll deny he does that. So where does the accountability come to the public and the consumer?
I think that's one of the things that we will tell the inspector to note specifically, that when they conduct these unannounced inspections, is this suspended director there? If so, what are they doing? Because again, I think it comes back to, I think the board can make an inference, but as your attorney, I would caution to look at the evidence that we have and that's in front of us. And we have the inspector seeing a limited interaction with this particular respondent.
Sure.
And we have two family members that say specifically, I never remember meeting with that individual. That would be hard to enforce action on, I think. So the reason for the recommendation of the letter of warning, we get this on the record, identify it specifically as an item point to be reviewed, and we send them later for the unannounced inspections. And then hopefully when we go back out there, we have better, more concrete evidence that time. And if it is an aiding and abetting situation, then unlicensed activity as well as aiding and abetting unlicensed activity.
So putting that motion that I mentioned, they already are going to be required to reapply. So there's really no point in putting that in the motion.
Correct. If they choose to reapply all of the things that you had mentioned in the motion, they would have to do anyway, just as part of the application.
And because of the suspension and then it expired, they have to come before the board regardless.
For the, so this, again, the suspension does not require them to come back before, but because they would have to reapply, once you go past your 90-day grace period, you start over. You're brand new. You have to reapply just like you would if you were applying for the very first time. Based on the disciplinary history of this individual, this would not be one we admitted.
It would automatically
Yes.
flag it.
Yeah.
Okay. All right, I'll make a motion to approve your recommendation. Council's recommendation. Second.
It's been moved by Mr. Nash and second by Mr. Haynes to approve council recommendation. All those in favor, sign aye.
Aye.
Opposed, have the same. Number 15, motion carried. Number 15.
Number 15, case number 2026024491. Complainant, daughter of the decedent, stated that their father passed away on April 3rd, 2026, and that they are the decedent's only child and next of kin. Complainant indicates they were not notified that their father had passed until 2 days after his passing, and by that time, a more distant relative identified as a great nephew had initiated arrangements with the funeral home. Complainant stated they have made attempts to contact the funeral home to assert their next of kin status, but respondent and the funeral home have, quote, refused cooperation and denied access to information, end quote, despite informing respondent they are the next of kin. Respondent replied stating that when they were initially contacted by the coroner's office concerning the decedent, the next of kin was listed as the nephew, and that they were never informed of a daughter by the medical examiner or by the nephew. Several days after the decedent's death, complainant came forward with the claim of next of kin. Respondent stated they tried to validate the information with the coroner's office and they did not have information on her relation to the decedent. Respondent claimed they tried to reach her on the number complainant had left with the funeral home, but that complainant would not return their calls. After finally making contact, respondent stated they made arrangements with her and that complainant wrote the obituary and attended the funeral and burial and received a flag from the military service. Respondent also indicated that complainant had retracted their complaint with the department and that the issue was handled before the funeral occurred. Respondent attached a copy of the email from complainant stating, quote, "Respondent, I have emailed the board to withdraw my complaint. I have forwarded the email as proof. Thank you again for your help, support, and understanding," end quote. Dated April 20th, 2026, complainant did in fact email the board to withdraw the complaint stating, quote, "Since submitting it, the funeral home has communicated with me directly and has worked with me in a respectful and professional manner to address my concerns. Please accept this letter as my request to close the complaint," end quote. Complainant submitted a rebuttal stating that some of what respondent had indicated in their reply was untrue and provided that respondent only tried to contact complainant after the complaint was filed. Complainant stated that after calling several times, they were told by the secretary that they would not talk to her. Complainant admits emailing the department to withdraw the complaint only because respondent had asked at the service if complainant would withdraw the complaint. Based on the above, we would recommend closure. I will say, while I recognize that complainant submitted a rebuttal somewhat refuting, at the end of the day, they emailed and put language that the respondent did not force them to put, requesting to withdraw the complaint. So that is the reason for the closure recommendation.
Hear the complaint, council recommendation. Any question?
Motion to accept.
Second.
Moved by Mr. Lee to accept council recommendation, second by Mr. Will. All those in favor?
Aye.
Opposed, have the same. Motion carried. Number 16.
Number 16, complaint number 2026026301. Complainant, brother of the decedent, filed a complaint against respondent funeral director alleging insurance fraud, forgery, and a fraudulent pre-need funeral arrangement. Specifically, complainant stated that the documents in the contract state that the decedent signed an insurance enrollment and pre-need funeral arrangement on December 23rd, 2025, certifying their identity with their driver's license. Complainant stated that the decedent was in the hospital from December 20th, 2025 in life-ending condition until January 20th, 2026, then transferred to hospice care until he passed on February 2nd, 2026. Complainant stated that on December 23rd, 2025, when he was purportedly signing the insurance policy, the decedent was over 100 miles away in the hospital. Complainant stated that ultimately a $5,000 check funded the policy without authorization and that $13,500 was transferred from his account to another individual's and that this person had printed the decedent's name by authority and signed his name under it. Complainant claimed they provided full information for the death certificate as next of kin, but that this other individual was listed as the informant despite, quote, providing minimal information, just his address, end quote. Complainant stated a respondent told him that the decedent had prearranged his funeral a long time ago, but claims that he later discovered this arrangement was actually dated December 23rd, 2025, and that the cremation authorization falsely listed a personal representative as the next of kin, not complainant who states they are the only living next of kin and gave no authorization to anyone. Complainant states by the time they discovered this, cremation had already occurred. Respondent replied stating that the funeral arrangements for the decedent were arranged by the aforementioned individual in complainant's complaint. This individual was the manager of the apartment complex that the decedent was a resident of, and a respondent stated that the individual reported to the funeral home that he would be handling the affairs of the decedent. The individual expressed that the decedent had a brother, complainant, who had been notified of the decedent's failing health, in which time the brother had been notified and declined any interest and offered no help to the decedent. The individual had a text message, which he showed to respondent, strongly expressing complaint's desire to not make any decisions on behalf of the decedent. As such, the individual took great concern in decedent's final arrangements as he would be transitioning to an assisted living facility and thus felt that any decision-making would be left in his hands. The individual made final arrangements by funding a prepaid burial expense trust and that the individual's actions were taken in good faith by the funeral home. Respondent stated that complainant's concerns of fraud of the individual signing checks on behalf of the decedent do not involve the funeral home, as there is no reason to doubt any of the individual's intentions as the only person with the right of disposition pursuant to 62-5-703. Likewise, respondent indicates that complainant did not have knowledge, sorry, that's a bad typo, did have knowledge of the cremation taking place because respondent had spoken to complainant when getting information for the death certificate involving the bio parent's name. The pre-need sales agent who wrote the contract also provided a brief response, stating, quote, "I admit having made a mistake regarding the identifying sick of the individual. I must have thought in my mind it was referring to the individual. I am unable to recall the application being in front of me," end quote. The sales agent then states that due to a medical procedure, they, quote, "do not remember much that happened until the procedure." Respondent attached documentation, the first of which is a text message from complainant to the individual, where the individual showed to respondent. Complainant states in this text message to the individual, quote, "I need to be clear that I am not taking responsibility for decisions regarding his belongings, finances, or accounts. Any matters related to his or property will need to be handled through the appropriate legal agencies," end quote. Additionally, respondent attached a text message from the individual to complainant and 3 other individuals dated February 2nd, 2026 at 5:02 p.m. Quote, decedent passed away at 3:25 today at the nursing home. He is at respondent funeral establishment and will be cremated and buried in cemetery, end quote. Complainant did not appear to respond to this text message. Complainant provided a rebuttal stating that they are the decedent's next of kin and did not provide written authorization for the individual to act on their behalf regarding disposition decisions and claimed they did not waive their right of disposition. Complainant also states that if the individual did sign the decedent's name on the pre-need funeral arrangement contract and related insurance documentation, raises significant concerns regarding authority and identity verification. Complainant stated they spoke to respondent one time when respondent called to verify one item on the death certificate information, and that complainant did not bring up arrangements or next of kin with him. Complainant also stated that the decedent had made pre-need arrangements, quote, "a long time ago when he first moved to Tennessee," end quote, which was in 2015. Complainant stated they relied on this and took respondent at his word, but was later told that pre-need arrangement was not executed until December 23rd, 2025 by the individual. Based on the above, there appears to be 2 columns here. Column A, involving respondent as the funeral director and next of kin determinations, and column B, involving the pre-need sales agent and pre-need issues such as the signature of the individual on behalf of the decedent. It is legal's recommendation that the board only make a determination as to column A, as that is our respondent in this case, and is within the board's jurisdiction. Legal recommends that a complaint be administratively opened against the pre-need sales agent, where the issues that fall under column B can be determined by the appropriate program. For issues involving column A, the following appears to be relevant. Respondent was presented with a text message from complainant to the individual, which complainant, quote, "was not taking responsibility for decisions regarding his belongings, finances, or accounts," end quote. Respondent appears to have relied on this as complainant's surrendering of the right of disposition and says that the individual suggested as much. This led respondent to working with the individual under 62-5-7039 as the individual was the, quote, "personal representative." The individual presented the text message to respondent from February 3rd, 2026, informing complainant and other individuals of the decedent's passing. Based on what was provided here, it does not appear that complainant responded to this message, which could have further led respondent to believe complainant was not involved and did not want to be involved in the arrangement process. Complainant and respondent spoke over the phone once, in which respondent inquired as to the name of the decedent's biological parents. Respondent did not inquire as to whether complainant intended to use their right of disposition. Complainant also did not express or come forward with their right of disposition. Purportedly during this conversation, respondent alleged decedent said a pre-need contract had been executed a long time ago when the decedent first moved to Tennessee. The relevant pre-need contract appears to have been executed December 23rd, 2025. In speaking with respondent indicated he told complainant that the individual and a sales agent had done a pre-need contract a few months ago, but denied saying anything to the effect that indicated this contract had been entered into several years ago. Respondent further stated that the individual had come forward on a few occasions where an elderly tenant had no family or anyone willing to oversee their care as next of kin. Respondent stated while this was not necessarily common, he had worked with him previously and trusted this individual to come forward on people's behalf when they had no one else. Respondent stated when the individual showed him the text message from complainant and the individual represented he was responsible for the arrangements of the decedent, respondent had no reason to doubt or question him. Respondent also stated that despite complainant's claim he didn't know the decedent was being cremated, when respondent spoke with complainant, he had informed him the decedent was to be cremated and even invited him to the burial and service. Despite this, as respondent says, complainant did not assert their right of disposition during this conversation. Ideally, upon being presented with a text message, his legal's opinion, respondent should have contacted complainant directly to confirm, preferably in writing, that complainant did not wish to invoke the right of disposition. Arguably, however, complainant may have forfeited their right of disposition under 62-5-7042. Complainant knew of decedent's passing on February 3rd, 2026, based on the text message, and also allegedly knew of the plans of disposition during complainant and respondent's conversation, and does not appear to have asserted his right of disposition at any time until after the services occurred. The board's determination should be whether it was a violation of professional conduct on behalf of respondent or a violation of 62-5703 to permit the identified individual to act as the next of kin in light of complainant's text message and not coming forward asserting the right of disposition during their conversation or upon learning of the decedent's passing. So based on the above, legal would recommend a letter of caution regarding direct communication of individuals who are forfeiting their right of disposition, as well as an administrative opening of a pre-need complaint against the pre-need sales agent identified in the complaint.
Board members, you heard the complaint and council recommendation. Any questions?
Motion to accept.
Been moved by Mr. Lee and second by Mr. Hank to accept council recommendation. All those in favor, sign aye. Aye. Opposed, have the same. Motion carried. Number 17.
Can I interrupt? Can we take like a 5-minute recess?
Yes.
Ms. Bowen?
Go ahead and get up, just remember, it's still in.
Mr. Bryant,
Yes.
number 17.
Next complaint number 2026-022-021. Complainant stated on March 6, 2026, complainant contacted respondent establishment to arrange for the transportation of the decedent, their mother, from a hospital and were told that the respondent establishment would handle the pickup and keep them informed on arrangements. Complainant stated the following day they called to confirm whether the decedent had been picked up and were assured that they would receive updates regarding next steps. On March 9th, having received no updates, they called respondent establishment and were informed that the decedent had been embalmed on March 8th. Complainant indicates they were never notified prior to this procedure, nor did they give authorization for embalming. After learning that the decedent had been embalmed, complainant requested that the decedent be transferred to another establishment. However, complainant states they were informed by a funeral director of respondent establishment that the decedent would not be released unless a payment of $1,895 was made for the transportation costs. Complainant states, though the manager indicated they would not be charged for embalming since it was done without complainant's knowledge, complainant stated they have reason to believe, due to the amount quoted, that the amount owed included both transportation and embalming costs. Complainant alleges that when they requested an itemized statement of charges, their calls were no longer answered and their emails went unanswered. Complainant further alleged that since they were out of state, they had their uncle go to respondent establishment in person to request this documentation. Complainant alleges that the funeral director reportedly locked the doors of the funeral home and refused to provide the requested itemization, and that following this interaction, the manager ceased all communication entirely. On March 10th, complainant's aunt was able to contact the owner, who indicated complainant would not be required to pay the $1,895, but that after the communication, the owner also stopped replying. Complainant filed their complaint on March 11th, and on March 12th spoke with spoke with a funeral director who is the respondent in the next complaint, who allegedly stated, quote, "Why would I reduce my price if you're going to contact the FTC?" End quote. On March 13th, the decedent was transferred to another funeral establishment, with the new establishment informed complainant that they did not receive an itemized bill from respondent, but that payment still had been made in order to secure the release of the decedent's remains. I had erroneously put this as the manager responded. Is that right? Let me double check. The distinction probably doesn't matter, but I just want to make sure I'm not misrepresenting on that. Okay. Where that says manager, it should state funeral director of respondent establishment. The individual who's replying for this one is the respondent in the next complaint, I think is the important part. Funeral director of respondent establishment replied stating that the decedent came into respondent's care on March 6th after picking the decedent up from the hospital. Respondent stated that over the weekend, complainant contacted the answering service with a question regarding the disclosure of information. It was told that she would be contacted the next business day to arrange services.
I'm
Respondent-
sorry, Troy, can we hold on one second?
Sure. Okay. I'll just start back from the respondent's reply. Funeral director of respondent establishment replied stating that the decedent came into respondent's care on March 6th after picking the decedent up from the hospital. Respondent stated that over the weekend, complainant contacted the answering service with a question regarding the disclosure of information. It was told that she would be contacted the next business day to arrange services. Respondent stated during this conversation, the complainant never discussed or requested cremation services and did not give instructions to prohibit embalming, and that the only acknowledgement provided by complainant was that she agreed to be contacted to make arrangements. Respondent stated upon being made aware of complainant's desire to transfer to another funeral establishment, they, quote, immediately acknowledge their right to select a funeral provider of their choice and disclose their forwarding of remains fee in the amount of $1,895, end quote. Respondent stated complainant became verbally hostile and used abusive language, and that later that day, a, quote, unidentified male arrived at the funeral home, rang the doorbell, and handed them a phone with complainant on the line, demanding the forwarding cost. Respondent stated after providing the same fee, complainant responded with further verbal abuse, and respondent terminated the interaction and reiterated that all funeral arrangements must be coordinated through their newly chosen funeral home. Respondent stated that, quote, no written authorization, documentation, or formal request for transfer was provided directly by the family at that time, end quote. Respondent stated that a representative of the new funeral home arrived at respondent establishment and was provided a general price list. Respondent does not indicate that a general price list was supplied to the complainant or the family. On March 13th, 2026, the new establishment contacted respondent and formally requested transfer of the decedent and that the forwarding of remains fee of $1,850 was disclosed and accepted. Respondent stated that the decedent remained in their care from March 6, 2026 until March 13, 2026, and due to the absence of refrigeration at respondent establishment, quote, and consistent with public health standards and the rules of the Tennessee Board of Funeral Directors and Embalmers, the decedent was embalmed after 48 hours. This action was taken to prevent decomposition, protect public health, and preserve the dignity of the deceased, particularly in light of the anticipated delay in final disposition. At no time did respondent establishment receive express written authorization for embalming from the legally authorized next of kin prior to the procedure being performed. However, due to the specific circumstances present, embalming was carried out under implied necessity and in good faith, end quote. Respondent argued that under Title 62, Chapter 5, that they had, quote, an affirmative duty to ensure the sanitary care, preservation, and public health, end quote. Respondent further stated that no alternative method of preservation was available and that they had not received, quote, timely direction for immediate disposition or removal, end quote. Respondent argues that the need to embalm, quote, must be evaluated in light of the totality of circumstances, including the absence of refrigeration, the passage of time, the lack of timely instruction, and the professional obligation to prevent decomposition, end quote, and that in order to prevent a risk to public health, safety, or the condition of the remains, quote, the funeral establishment is permitted to take reasonable and necessary preservation measures under implied consent, end quote. Respondent closes by stating the $1,850 charge was solely for the forwarding of the remains. Based on the above, respondent admits they embalmed without permission, but that this was due to a larger duty of public health and safety. As evidence of this, respondent indicates that complainant during the call to the entering service never told the entering service not to embalm the decedent. However, complainant stated that the entering service specifically told them someone would reach out on Monday to discuss arrangements. This presumably would include a decision regarding embalming. From legal's view, to expect a consumer to discuss those details with an answering service when being told specifically that someone from respondent establishment will be in contact to make arrangements the following business day is a difficult standard to hold the average consumer to. During this interim, the decedent was embalmed without permission. Additionally, complainant alleges they never received a general price list or itemized documentation showing the cost of the transfer or embalming. While respondent indicates that complainant was charged for transfer only, complainant has no way to confirm this without ever having seen an itemized price list. Respondent only indicates that the new establishment was given the general price list upon transfer, but does not state that complainant was ever provided this documentation. Failing to provide a price list to complainant is in and of itself a violation. Based on the above, I would recommend a $1,500 civil penalty authorized via consent order and formal hearing if necessary.
You heard the complaint and legal's recommendation. Any questions? If no questions, I get a motion.
Motion to accept.
Second.
Been moved by Mr. Lee, second by Mr. Nash to accept council recommendation. All those in favor?
Aye.
Opposed have the same. Motion carried. Number 18.
Number 18, complaint number 2026022011. Respondent in this case is the funeral director from the preceding complaint. Based on the above, would recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
You heard the complaint and recommendation from legal. Any questions?
Motion to accept.
Second.
Moved by Mr. Lee, second by Dr. Allen. To accept council recommendation. All those in favor? Opposed have the same. Motion carried. Number 19.
19, complaint number 2026-035401. Complainant mother of the decedent stated that respondent had, quote, stalled several days and was, quote, claiming to be waiting on a permit, but was not, quote, providing clear information on location of my daughter's remains and status of the death certificate, end quote. Complainant stated on April 29th, 2026, a Wednesday, they were informed that their daughter had passed away and soon after discovered the decedent had been taken to respondent establishment. Complainant stated when arriving at respondent establishment, the office was closed and the phone number went to an answering service. On Friday, the decedent's sister received a call that the decedent's body was at a crematory that was not respondent establishment and that they were free to come view the decedent at 1 p.m. Upon arrival, complainant stated a woman at the crematory indicated they would go into a conference room to sign documentation. Complainant said they refused to sign any documentation, and complainant alleges that at this, the woman, quote, closed and locked the door in our face and said, you are going to have to leave, end quote. Complainant stated that to date, they have not seen the decedent's body as of the date of the complaint, which was filed May 6th. The manager of respondent establishment, who is the respondent of the next complaint, stated that throughout the arrangement process, they dealt with the decedent's husband, who warned them that the decedent's sister was, quote, very hostile and was demanding to view the body, end quote. Respondent stated after completing the arrangement process, they informed the husband of his options, and he reluctantly agreed to let the sister view the body. Respondent stated the body was already in the cooler at a separate cremation company, so respondent reached out to their employees to coordinate a time for the viewing to take place and told the husband respondent, would coordinate with the sister so he could remain uninvolved. Respondent stated upon calling the daughter to arrange the viewing, quote, she was hostile from the very beginning, asking questions like, how much did husband pay for this? Why would husband be so cheap? Why would he not call a funeral home? End quote. Respondent stated they informed the sister that their duty was to the next of kin and that he had given permission to view the body and he was only attempting to coordinate that. Respondent stated that complainant's recollection of the day was inaccurate and provided that he received a call from the crematory employee from her vehicle stating that the family had arrived, quote, been hostile and verbally abusive, and she had locked herself in the vehicle and that the family pulled their car behind hers to block her in, end quote. Respondent stated the employee informed him that she had called the police and were awaiting their arrival. Respondent called the next of kin and informed him of the situation, and thus, at the next of kin's request, the family no longer be allowed to view the body. Respondent relayed this information to the employee, who informed the police. Respondent stated at no point was protocol broken, and they tried to handle the situation as amicably as possible, but it became a matter of the establishment getting caught in the middle of a family situation. Based on the above, we would recommend closure.
You've heard the complaint and council recommendation. Any questions?
Motion to approve recommendation.
Second.
It's been moved by Mr. Nash and second by Mr. Wheeler to approve council recommendation. All those in favor, sign of aye.
Aye.
Opposed have the same. Motion carried. Number 20.
Number 20 is complaint number 2026-035451. Respondent is the manager from the preceding complaint. Thus, we would also recommend closure.
You've heard the complaint and council recommendation. Any questions?
Motion to accept recommendation.
Second.
Moved by Mr. Nash, second by Mr. Wheeler to accept council recommendation. All those in favor, sign of aye.
Aye.
Opposed have the same. Motion carried. Number 21.
Okay, the next four complaints all go together. They're all received kind of around the same time. So what I will plan on doing is just reading through them, and I try and line out my recommendation for each one as cleanly as possible at the end of all four. But as we're going, if you all have any questions, please just feel free to jump in. So 21 is complaint number 2026-022681. Anonymous complainant alleged that respondent was advertising a funeral home that was not licensed with the state of Tennessee. Complainant stated that respondent had done an interview with a local radio station announcing the funeral home prior to its licensure. Complainant attached a screenshot of a Facebook post made by the radio station regarding the respondent and the establishment. The radio station uses the establishment name, which was not yet licensed, several times. However, respondent does not state the name of the establishment in the quoted portion of the post. Respondent replied, stating that the local paper and radio station ran a story of their return to the industry and that respondent had no control over the article. Respondent attached a copy of the entire article that specifically stated they are not yet in business and refers, quote, going back in business, end quote. Respondent stated they have been working to secure the purchase offer and straightening out issues while the license application was being reviewed. In the provided article, respondent is quoted as saying the following, quote, families deserve honesty, dignity, and confidence that their arrangements will be respected. Establishment name is built on those principles, and we are committed to serving this community with compassion, affordability, and integrity, end quote. So we'll look at the next three complaints that also involve essentially the same article. That involves complaint number 2026-030951 against the funeral establishment. The department received another anonymous complaint, this one filed against respondent establishment from a concerned citizen, pointing to the same news article about the return of respondent establishment. Complainant points to the fact that the article concludes with a sentence stating that the information in the article was, quote, provided by respondent establishment, end quote. Complainant indicated that this was false advertising as respondent establishment did not yet have a funeral establishment license. Respondent further reiterated their response from the previous complaint, adding that the press release clearly states that they are not open at the present time, but hope to be in the coming days or weeks. Respondent reiterates that there was no paid advertising or marketing prior to receiving their license. Next complaint is complaint number 2026-028311, filed against the funeral director from two complaints earlier. Complainant made similar allegations, stating that respondent had advertised and posted the name of a funeral establishment prior to its license approval. Complainant provided the same news article as well as a Facebook page from the establishment, indicated that they had updated their profile picture. The updated picture was made from respondent establishment name's Facebook page. The update just said 3H, meaning 3 hours ago without a specific date, but the complaint was received by the board on April 25th, 2026. The establishment was granted their establishment license on May 13th, 2026. Respondent reiterated the response from the previous complaint. Notably, this complaint was filed against the respondent individual, not the funeral establishment. At all times relevant, respondent, the funeral director, was appropriately licensed. And finally, complaint number 2026-030921, again against the funeral director. Another anonymous complainant presenting themselves as a concerned citizen largely reiterates the allegations included in the three preceding complaints. Complainant provides the same newspaper and online articles, and respondent reiterated their response from the previous complaints. Looking over the previous four complaints, the relevant rule is 0660-01-.032, which states, a licensee shall not permit any advertisement, price list, brochure, business card, signage, internet website, or other written medium that is likely to be viewed by the public to refer to the funeral establishment name by any name other than the exact name listed on the establishment application approved by the board. Here, there had yet to be any name approved by the board regarding the establishment licensure. The establishment is now properly licensed. The question before the board is ultimately whether a news article, not directly written or published by respondents, but contributed to by way of interview, constitutes permitting the name of the funeral establishment to be made available to the public prior to approval of licensure. After review of the attached complaints, legal would bring the board's attention to these facts. 1, respondents state that this was not a paid advertisement. The local news radio station sought out respondent to cover a story regarding their return. 2, however, during this interview, the funeral director stated the name of the establishment that was returning but had yet to be licensed. The funeral director is quoted specifically as stating the name of the establishment despite not having received proper licensure. Respondent points to the fact that in the interview they specifically mentioned that the establishment is not yet open for business, but this cuts both for and against respondent's favor. While the disclaimer that respondent establishment is not yet open for business supports the fact that this was not intended to be a specific advertisement prior to appropriate licensure, It also settles any debate that respondent establishment was not yet appropriately licensed. The rule does not state that the licensee may not intentionally advertise a yet to be open establishment. It instead states, quote, a licensee shall not permit any written medium that is likely to be viewed by the public to refer to the funeral establishment name by any other name than the exact name listed on the establishment application approved by the board, end quote. As respondent admits by stating that the establishment had yet to be open for business because they were waiting on licensure, the approved name is in fact no name at all. 3, the Facebook page, while not a post per se, still provides the name of respondent's establishment in a written medium while the application was still pending. Legal's concern is less that the profile picture of the page was updated, but more so that the Facebook page existed at all, as it was a written medium likely to be accessible to the public displaying the name of a funeral establishment yet to be approved by the board. Just some disciplinary history, just some precedent. Complaint number FUN 2026021881 was decided at May's board meeting, not this respondent, a different one entirely, in which an establishment website used the name of an unapproved establishment name in anticipation of a merger. The board assessed a $500 civil penalty. In complaint FUN 2026012771 was decided at April's meeting, in which an establishment had signage near the road of the establishment that included an unapproved name, as well as a plaque near the entrance of the building with the same unapproved name. The board assessed a $500 civil penalty. It is arguable when examining these two previous complaints recently decided that respondent and this complaints were less contributory to the violation than the previously two decided complaints. That is, the inclusion of an unapproved establishment name on a respondent's own website or signage predominantly displayed on the campus of the establishment are more within the control of the establishment in comparison to what a news program chooses to write in its publication. Respondent indicates that they did not ultimately have control over what the news publication chose to publish. However, respondent is still quoted as providing the name of the unapproved establishment and evidently provided the information necessary for the news outlet to publish the article. Also, perhaps the distinction for the board's consideration is the two older complaints were minor changes that, while they still violated the applicable rule, resulted in the inconsistency of the approved name. For example, changing Troy Bryant Funeral Home to Troy Davis Bryant Funeral Home. Here, we have the use of an establishment name that was once licensed, was no longer licensed for a period following its sale, and the return of the establishment with the use of its name prior to approved licensure. Again, this could arguably be either in favor of or to the detriment of respondents, depending on how you frame those facts. Legal encourages the board to consider the information provided, the applicable rule, previous case precedent, and to ask me any questions that you have. As a starting point to be adjusted as determined by the board, legal would recommend the following. For complaint number 2026028311, which is case number 23 on this legal report, closure due to allegations involving the funeral establishment and not the individual, which complainant filed against the individual respondent. Stated a little simpler to digest. The complainant filed that complaint against the funeral director, who at all times was licensed. If there were any violation, it would be against the establishment, not this funeral director. For complaint numbers 2026030921 and 2026022681, cases number 21 and 24 on this legal report, combined into one consolidated consent order for a $250 civil penalty, authorized via consent order and formal hearing if necessary. And finally, for complaint number 2026030951, case number 22 on this legal report, a $250 civil penalty, authorized via consent order and formal hearing if necessary. Any questions on that one?
Well, remember you heard the complaints and council recommendations. Any questions?
I make a motion to approve recommendations.
Can he do them in one lump, or do we need to?
I think you can, as presented for cases. Let's see. Let me make sure I get the right ones here. 21 through 24.
So we'll need to do 23 first and then 21 through 24 and then,
Not necessarily. I think the motion can be.
okay, I'm sorry, I want
Yep.
to make sure.
Yep, just from accept recommendations for cases 21 through 24 or whatever amendments anyone may want to make. Or,
I'm sorry. So
no.
I vote that I make a motion that we approve the recommendation for case 23, case 21 and 24, and case 22. Is that correct?
Yes.
Second.
Motion by Mr. Nash, second by Mr. Lee to approve council recommendations. All those in favor, sign of aye.
Aye.
Opposed, have the same. Motion carried. Number 25.
Complaint number 2026-036251. Complainant daughter of the deceased stated that their father unexpectedly passed away on December 26, 2024. Complainant stated they spoke with the respondent several times by phone and opted to use their services for cremation. Complainant stated it was their first time being in charge of someone's disposition, so they signed a document stating that they did wish for the decedent to be cremated with his clothing. However, when complainant went to pick up the decedent's cremated remains on January 24th, 2025, the decedent's clothing was also on the table in a separate bag, bright red, and a sticker that listed the decedent was wearing. Complainant stated due to the shock, they left respondent establishment without taking the cremains or the bag, and later contacted an employee owner respondent establishment. Complainant stated the employee never responded to any of the messages or emails. Respondent replied stating that they were the funeral director manager who met with complainant in early 2025, but not the employee complainant had attempted to contact. Respondent explains the body of the decedent was removed from the medical examiner's office, and taken to a crematory upon release of the complainant in January of 2025. When the decedent was picked up, a bag of personal items, the clothing, was also given to the driver and taken into the care of the crematory. The decedent was not dressed in clothing when received by the crematory. Respondent stated the form complainant signed included a box stating, quote, "I do wish for the decedent to be cremated with the clothing that they have on," end quote. Respondent stated that they did cremate the decedent with what they had on insofar as covering. Respondent stated they do not cremate belongings that accompany a body but are not physically on the body without written request from the next of kin, as the authorization form regards the decedent and clothing on the decedent at the time of pickup. Respondent stated at the time of pickup, complainant was provided with the cremated remains, the death certificates, and the offer of the return of his personal belongings. At the time, complainant was given the option of taking the belongings with her or requesting the respondent to respectfully dispose of them. Respondent indicated complainant chose to take them with her. Regarding the employee that complainant attempted to communicate with, respondent shared that those communications were made with the employee directly, not through respondent establishment. Respondent explained that the owner/employee reference no longer owns and is no longer affiliated with respondent establishment, and they cannot speak to their responsiveness in their direct communications. Complainant provided a rebuttal stating that they did receive the bag of clothes, but that they were in shock, upset, and couldn't think clearly. Respondent's rebuttal continues for several paragraphs, but essentially states that they were under the impression checking the box on the form would have the decedent cremated in his personal clothes, not necessarily just the clothes that the decedent arrived in. Complainant also seemed to assume somewhat reasonably that the decedent would have arrived in their own personal clothes. Regarding the former owner-employee, complainant theorized that they did not respond because, quote, he realized what they had done, end quote. Complainant questions why the individual who no longer works for or with respondent establishment would not apprise them of the change rather than ignoring the messages. Both complainant and respondent attached a copy of the same authorization document. Complainant's the executed version and respondent's a blank copy. The box checked by complainant states verbatim, quote, "I do wish for the decedent to be cremated with the clothing they have on," end quote. Based on the above, it appears to be an unfortunate circumstance where complainant made a somewhat reasonable assumption that the decedent would arrive in their personal clothes to then be cremated. However, the form only grants authority for respondent to cremate the decedent with the clothes they have on. Respondent indicates they offered to respectfully dispose of the decedent's clothes when complainant came to pick up the cremains. In their rebuttal, complainant claims respondents did not make this offer, but does also admit that she was in shock and upset. Regarding the former owner/employee, respondent indicates, and complainant's texts prove, that these communications were made in direct communication with the employee, not through the establishment. Based on the above, we'd recommend closure.
Heard the complaint and council recommendation. Any questions?
The only one thing I'd like to say is an observation. For those of us in funeral service, we know when you get someone, a decedent from the medical examiner's office, they never have the clothing on. They have always been removed. So on that, I sort of fault the funeral home a little bit because the ME always sends her clothing in a medical examiner's bag.
I make a motion to accept recommendation.
Second.
Motion by Mr. Nash, second by Mr. Haynes to accept council recommendation. All those in favor, sign of aye.
Aye.
Opposed, have the same. Motion carried. Number 26.
Next complaint is complaint number 2026036351. Complainant, daughter of the decedent, stated that their father passed away on May 7th, 2026. Complainant alleged that respondent had denied them transparency and disregarded them as next of kin. Complainant stated that they personally contacted respondent and informed them that she was the next of kin and provided her birth certificate. However, complainant alleges that despite verifying their identity and legal relationship to the decedent, respondent, quote, ignored and disregarded their status as next of kin. Instead, complainant states that respondent conducted arrangements through the beneficiary while refusing to communicate with complainant regarding the decedent's arrangements, cremation, and related documentation. Complainant stated on May 21st, 2026, they went to the funeral establishment to request copies of paperwork and documentation, but were denied because the beneficiary stated that complainant could not have access to the documentation. Respondent replied through counsel stating that the decedent left a life insurance policy naming the decedent's mother as the beneficiary. Respondent stated that complainant actively attended and participated in the funeral arrangements and was present along with the decedent's mother, beneficiary, the decedent's sisters, respondent, and staff members of the establishment. Respondent stated that all parties met to make arrangements on May 11th, 2026, and during this meeting, complainant forfeited their right of disposition because she was unable to pay for the funeral and did not want to be financially responsible. Respondent states that during this meeting, quote, complainant expressly agreed that the decedent's mother should make the arrangements given that she held the insurance proceeds, end quote. Respondent stated that this waiver and acquiescence to the decedent's mother making the arrangements was witnessed by at least 3 witnesses. Further, respondent argued that complainant further forfeited the right of disposition following acquiescence because 168 hours had lapsed since the decedent's death, and complainant did not further exercise their right of disposition within that time frame. As respondent argues, even if complainant wishes to exercise this right after the arrangement conference in which it was given to decedent's mother, complainant took no action to exercise their right within the 168-hour period. Respondent also provided a sworn statement from one of the sisters of the decedent who stated in part the following, quote, on May 11th, 2026, I attended the making of the decedent's funeral arrangements. The decedent's daughter, complainant, was present during the final arrangements. The decedent's mother was present during the final arrangements. Complainant waived her rights to control the disposition and declined to make arrangements for the funeral because she did not want to be financially responsible for the funeral. Decedent's mother stated she was the beneficiary of the decedent's life insurance policy and accepted the responsibility of making funeral arrangements. Complainant acquiesced to the arrangements made by the decedent's mother. Complainant participated in the remainder of the meeting and did not object to the arrangements made by the decedent's mother, end quote. Based on the above, we'd recommend closure.
You heard the complaint and council recommendation. Any questions?
Make a motion, we accept council's recommendation.
Motion by Mr. Wheeler,
Second.
second by Mr. Lee to accept council recommendation. All those in favor, sign of aye. Opposed, have the same. Motion carried. Number 27.
Complaint number 2026037881. Anonymous complainant alleged that an employee of respondent establishment uses the workhurst for personal purposes, including, quote, picking up his small children in it for multiple occasions, end quote. Anonymous complainant, who evidently has some manner in which to speak to the employee's small children, stated that, quote, his small children have stated on multiple occasions that he picks them up and lets them ride around with him in his body van, sometimes with deceased bodies in it since 2021, end quote. Anonymous complainant stated that the rumor is that respondent establishment is aware of this, but they have not verified whether that is the case. Additionally, anonymous complainant stated that, quote, "The children have also advised on multiple occasions that since 2021, the employee would have them hang out at his work at the funeral home with him at times," end quote. Respondent replied stating that the reference vehicle is a utility flower van owned by respondent and that the employee, quote, "was granted permission by management to temporarily use this vehicle for personal transportation while their personal vehicle was undergoing maintenance. This was authorized and known by the funeral home," end quote. Respondent stated they investigated the claim that minor children were transported in a vehicle used to carry deceased human remains and confirmed with the employee that the children had never been transported in a vehicle containing deceased persons. Respondent indicated that while the vehicle may occasionally be utilized for funeral home operational purposes, there was no evidence of any improper, safe, or unlawful conduct involving the transport of children. Respondent provided context to the motivations of the anonymous complainant, providing that the employee and a former spouse are engaged in a contentious custody matter. Respondent stated that the allegations are consistent with a pattern of ongoing personal conflict and harassment directed towards the employee. Anonymous complainant provides no proof, evidence, or even an allegation involving their firsthand knowledge that would result in the violation of applicable laws or rules. Therefore, we recommend closure.
Heard the complaint and council recommendation. Any questions?
Motion to accept.
Second.
Motion by Mr. Lee and second by Mr. Nash. To accept council recommendation. All those in favor?
Aye.
Opposed have the same. Motion carried. Mr. Bryant, on behalf of this board, we want to thank you for getting us through this today. Job well done.
And you should
Thank you.
buy the interns lunch for this. Something really nice.
I think they owe me lunch after.
I disagree.
At this time, we're gonna move on to Director's Report. Mr. Gribble.
Thank you, Mr. President. Board members, I'm going to make this very brief. This is a report of the licenses that have been issued from May 9 to July 11, 2026. We have two funeral establishments that reported closing: Edward Hatch Funeral Home, 3922 Gallatin Road in Nashville, and Fell House Memorial Chapel, 2022 North Main Street in Sheffield. Also contained in this report is the disciplinary action report. Its consent orders have been administratively accepted or approved by the executive director pursuant to the board authority, as reported on the April 2026 and May 2026 regulatory board's disciplinary action reports. And lastly, the complaints report as of July 7, 2026, we had 72 total complaints, 34 of those against the funeral director and embalmer and 38 against the establishment. I'll be glad to answer any questions, but that concludes my report.
Any questions from the executive report, Mr. Gribble's report?
I make a motion, we accept Mr. Gribble's report.
Second.
It's been moved by Mr. Wheeler and second by Mr. Lee to accept the executive director's report. All those in favor, sign of aye.
Aye.
Opposed have the same. Motion carried. We have anyone appearing before the board today, Mr. Gribble?
Yes, sir. We have an individual application, and they're appearing virtually. Mr. Rick, if you could, go ahead and turn your camera on for the board, please. This individual is Rick Allen Holstein of Cedar Falls, Iowa, who is an application for funeral director and embalmer license through reciprocity from Iowa and South Dakota. The reason he is before you today is education requirement can be waived by the board under 62-5-311. We have all the documentation in order, fees paid. It's just the board has the authority, since he's been licensed for 5 consecutive years and been practicing as a funeral director and embalmer, to grant the license without the associate degree. He has a diploma in funeral service. We could have approved the funeral director application, But since he needed to appear before the board for the embalmer, we just kept them both together. Are you there, Mr. Rick? Mr. President, in the essence of time, I would suggest, unless you have a specific question you want to ask him, to just
Any
go ahead with you.
questions?
Does he still take the state board laws exam?
Yes,
Yeah, so he passed
he's
it.
and he's
He
passed
passed
that.
it.
Okay.
He's met all the requirements. The only thing he doesn't have is an associate degree, and Mr. Bryant could explain that probably better than what I did. But the board has the authority to grant the license since he's been licensed for several years in 2 other states.
Yeah, I mean, just in essence, you have all of your various boxes that you need to check to become licensed. One of those specifically, I can pull the statute up in just a second, but specifically, if they have been licensed elsewhere for a period of 5 consecutive years, that can, with board approval, cover one of those boxes that ordinarily would need to be checked.
He's got well over that, looking at this, I think. I make a motion, so can we approve this without him appearing?
If you agree to
Agree
it,
to it.
that's your option.
Do we just to suspend rules or anything like that, or anything? Okay.
Mr. Rick, he messaged me, he emailed me and said he had to step away after 3 hours.
Okay,
So he has been online
Okay.
the whole time and we have been communicating, but
okay.
after 3 hours, he had to step away.
I mean, I make a motion that we approve the license. I don't see anything wrong here.
I'll second.
Motion by Mr. Nash, second by Mr. Wheeler to accept the applicant of Mr. Rick
Holstein.
Folsom. All those in favor?
Aye.
Both have the same. Let Mr. Wholesome know that, he's now will be a licensed film director in the, state of Tennessee. Any other?
We had a matter to present to you. I don't see that person or anybody representing the establishment online. Okay, that person is there now. I'm sorry. Probably there all the time, and I just couldn't see the screen to see that. This is
Mr. Gribble?
I'm going to recuse myself from this one.
okay. Okay, this is an establishment that's moving locations. It's Circle of Life Cremation LLC. Jennifer Sutherland is the manager. She has moved to 1717 Boyd's Creek Highway, Suite 104A in Seymour. It's a limited liability company, and Circle of Life LLC is the owner of that company. As a point of information, the information for the Tennessee Secretary of State, Department of State, the revenue standing is not in good order. Normally, when the board is looking at any kind of application or change, we normally check the LLC or the corporation, and there are about 4 things to be in order. Now, I know that the inspector contacted Ms. Sutherland and talked to her about that, and I believe she thinks she got everything in order, but there evidently is one other thing, because this is normal, they file the reports, but evidently there's still one other fee or something to pay. So there's something there that's not in order. And on the planning and zoning letter, it refers to it as Seymour, Tennessee. And on the sewer, it says Sevierville, Tennessee, same address. I don't know which that is, but anyway, besides whatever other questions you wanted to, and I guess what you probably want to do is let Mr. Sutherland make an opening statement. And if you don't care, Mr. Sutherland, go ahead and turn your camera on if you can, and make whatever statement you want to the board, and then they can ask whatever question. you have anything to say.
Ms. Sutherland, can you hear us?
Yes, I can. Can you hear me?
Yes, ma'am.
Okay. Well, I'm having difficulty. I'm not quite sure what's going on, but anyhow, yes, I have moved to a new location and just, you know, waiting for approval of my new location.
Mr. Grivel, you say she still has, is it two?
There was two
Two items?
Two items. You said there was something with with the Secretary of
LLC?
State and something else.
The
The sewer letter.
the sewer letter, and I don't know I mean, I'm just pointing that out to you. I don't know if it's a problem with, one of them refers to him as Seymour, because then the other one is Sevierville. The other thing was with the Secretary of State, the revenue standing was says not good. The other three items there are good, but the revenue standing is not good.
Okay, I am in Seymour, Tennessee. And I contacted Secretary of State, and which you mentioned this while ago, but yes, I thought everything was taken care of.
If I could ask Mr. Bryant, has this establishment been before this board before with any complaints?
Yes, they have. I think the main thing to consider on this application for change of location is with the remaining issues with the Secretary of State's office that still need to be addressed. It sounds like Ms. Sutherland has addressed or attempted to address some of those, but some remain outstanding. I've not seen that typically be flagged in a change of location application before, and I'm not positive if it is one of the I know Mr. Gribble may do that check, but if it is the typical statutory checklist required to go through. What I think the main thing for the board to focus on, because if there are underlying issues with the Secretary of State and the LLC representation of that, candidly, that would be its own complaint. And own issues that need to be sorted out as quickly as possible. But I think what the board should primarily be focused on is the fixed place of business rule, where the key is in this one under section 2. The board, in determining whether an applicant's proposed fixed place of business or establishment is devoted to the care and preparation of dead human bodies, may consider factors including, but not limited to, the following. And there are a number of those factors there. Any indication in the proposed establishment's name that suggests the establishment will be engaged in activity other than the care and preparation of dead human bodies. From my review, I don't think there's anything in the name that would suggest that. I think primarily the ones at play are D. If the establishment is located within a business complex whether the establishment is clearly separated from any other entity located within the complex and clearly distinguished by professional signage. And again, it says not limited to. So the board, I think, has a wide array to consider whether something would be a sufficient fixed place of business for a funeral establishment. And in your packet for this application, I think starting on page 23, you can see the photographs that the inspector took of this location. And my understanding is that when you walk up the stairs into the suite there, the first door on the left, suite 104A, would be the proposed establishment area. And then there are a couple of pictures of that room and a shared restroom between the other suites on that hallway.
Does the Secretary of State give any indication as what needs to be completed or what she has not completed? It looks like she, sometimes I know there's annual reports and there's something like that, but sometimes you have to do that. Plus you have to have it reactivated or not reactivated, but
This is probably a fee that still needs to be paid. I do think that Ms. Sutherland thought that she had everything in order.
Okay.
And like Mr. Bryant said, this might be something not even to be considered for this. It might be something separate and different to discuss at a later time. It's something that we check when, when we do an application
Right.
of any type.
right.
And,
Ms. Sutherland, the building where you're at, where your office is going to be, will you have any exterior signage there with your business name listed on it?
Yes. Can you hear me?
Yes,
I'm so
ma'am.
sorry. Can you hear me?
We can, yes,
Okay.
ma'am.
So, and I sent, I did email Miss Bohannon photos, okay, so at the road, there is I think it says Seymour Professional Building. Okay, so I will have, I will have a sign on that so then once you go to the top of the steps on the second floor where I am, there will be an exterior sign there as well beside the door that says, 104.
Okay.
And then once you walk in, I'm the very first and second door on the left, and there will be signage beside each of those doors.
And I'm looking at the photograph inside your office, and so I can see your desk and everything, and I can see it looks like an arrangement table. Is that second door kind of past, I guess I'm gonna call it the armchair in the photo?
Yes, the second
Okay.
door is, it's just,
So it's not a
it's
second
just,
room to your suite. It's just one
no,
large room.
one big room with two doors. Yeah, the second door it is down in the area of the arrangement table. Yes, sir.
And then the restroom that's shared by the suites, is it located separately or is it inside one of the other suites?
Yes, you go out, let's just say you go out of the second door.
I'm looking at the hallway photo.
Okay, so, I was just gonna let you know, you go
Mhm.
out of that second door of my office and, take a left and then, I don't know, 5 steps and
Mhm.
take another left, and that leads you to the restroom.
Okay, so there's like another little hallway or something, or a little opening.
Yes, yes.
Okay, I see. I zoomed in. I can see it now. Okay, sorry. Just trying to make sure I understood where it was. And
Okay.
the other businesses that are there, how active are those businesses?
No, okay, so so just beyond me, there is another suite. So from what I understand from the um, landlord here who owns this property, this complex, he has told me that this gentleman is a therapist in South Carolina. Uh, and he is also a therapist in Tennessee. So he needed to have an office, of course. And he did tell me he has He's never seen him. He's never been here. And then right directly across from me. So when you walk in the door and on the right, there are 3 doors, and they're all occupied by the same person. And I'm told by the landlord that she only comes in the evenings.
Okay, okay.
Like if she comes, it's in the
Sure.
evening.
Sure. Okay. Um, my other question was regarding, and now I asked you those questions and now I see your letter explaining that. I'm sorry to have you, I should have read that. I apologize. You use Littlebrook Cremation to do the cremations for you, that's correct?
Yes.
And so when you receive a call from a family to pick up a decedent, the removal service, do they transport them directly to Littlebrook
Yes.
for you? Okay. And do you provide any kind of services anywhere else? Like do you take care of church services for families and things like that, or just simply just take care of the cremation and
Yeah, just the cremation.
okay.
That's all I've ever, that's all anyone has ever asked of me. They want direct cremation.
And do you own this establishment as well, or are you just a manager that works for an employer?
I own it.
Okay.
So a couple of questions. When you have a family, Ms. Sutherland, that wishes to view the decedent before they're cremated, where does this take place?
Okay, it can take place at the crematory at Littlebrook Cremation Company, or it can take place. I have an agreement with Bill Bourne with Jarnigan and Son that they can have a viewing there.
Is that agreement in this paperwork you submitted with the state?
No, it is not. And I have spoke with him even as recent as yesterday. What he asked me, he told me his price, what he would like to be paid for it. And then he asked me if I could please just type this up and email it to him, and he would put it on his letterhead and sign it and send it back. So when I spoke to him yesterday, to remind him, please do this. I have not received it yet. He said that he has been sick. So I do not, that is the situation. He did verbally agree over the phone that yes, he would let me do that. And he gave me his price. And, but he did state that yesterday. He's been very sick.
Are these prices on your general price list?
Yes.
So you have a price on there for viewing at another facility?
Viewing at Littlebrook and then also viewing at Jarnigan. Yes, sir.
And it is on your price list, your GPL?
Yeah.
Okay, but you don't have a letter submitted to the board stating that this agreement lies between you all?
I do not, because when I was inspected, this was told to me. I mean, at that point in time, I had this agreement with him, and I had already at that point asked him, please provide this letter to me.
Okay,
And
I understand that, Ms. Sutherland. I'm just asking the board, you've submitted nothing in writing that there is agreement lies between you and Mr. Bourne or Littlebrook Cremation.
She has a letter from Littlebrook.
Okay,
Little-
but nothing from Jarnigan and Son.
no, I do not. And
Okay. And my next question is, for someone who has a handicap, how are they going to be able to get to your office?
Okay, as I had stated in the, the letter that I wrote, Mr. Shannon asked me to, I will, if we will do everything online and email, or I will go to their home and take care of everything.
But I guess my question is, what what are you going to do when you have a family that wants to come to your facility? Not everybody has online ability and they want to come in, especially if they want to view their loved one.
Okay. Um, well, I can, if they want to come here and they are not able to climb the steps, then the only options that I have to offer are that we do everything online, or I go to their home and take care of arrangements.
Mr. Gribble.
Any more questions?
So is this primarily brought to us because of the Secretary of State issue or what's primarily what we're looking at?
I would say the primary issue is the fixed place of business rule, whether the board would determine that this is a suitable fixed place of business as defined by the rule and for the factors listed in those rules and any other factors that the board determines to be relevant.
I agree with Mr. Wheeler that, I mean, and I know that she addressed it in her letter that there's the accessibility could be an issue for some folks because of the stairs. But as far as the way that the room is, the office is set up with the shared restroom, we have approved applications previously that do that as well, correct?
Correct. From my recollection, there have been others that have a similar shared facilities system that have been approved.
Mr. Nash, one distinction here is the others that have been, that I can recall that have been approved by the board have a shared access to a shared conference room as well, and not just their office.
Correct. And it looks like she has her own conference room in that office. Just the office, it's not separated. So it needs to be a separate.
Yeah, historically, there's been at least two rooms
Correct.
that are,
Correct. I understand that.
that are divided by a solid wall with
Sure.
doors,
Sure.
accessible to either one. And if there's been only one room, to my knowledge and recollection, then that entity has had access to a shared conference room and a shared restroom at a minimally that.
Any more questions? Okay.
Can I say something, please?
Absolutely.
Okay, so Kimmons Mortuary Service in Murfreesboro, Nashville area. Nashville. It was approved on August of 2021. And when watching, his board meeting, when he is describing his office, it sounds very much like mine. And also, Cremation Services of Knoxville, who actually, they were with me when going before the board, August 29th of 2023. He is on the third floor, and when describing his office to the board, he states that he is on the third floor and he shares with others, including an insurance company and a therapy practice with a shared restroom. He is also, it's an office suite. So, I don't know, I guess that sounds a lot like what I have here.
I think, and if I can weigh in a little bit as well, I think the key for the board to consider is, so in statute, fixed place of business, it's not very helpful. All it says under 313, every person, firm, partnership, or corporation at each and every place of business conducted by that person, firm, partnership, or corporation in the business or practice of funeral directing shall have a fixed place of business devoted to the care and preparation of dead human bodies. That is essentially all it says in statute. The rule carves it out a little more, and those factors that I read earlier. I think the key determination of what constitutes a sufficient or insufficient fixed place of business, the board in determining whether an applicant's proposed fixed place of business or establishment is devoted to the care and preparation of dead human bodies. That is the standard. If the factors in here, limited but not including but not limited to the factors listed in rule, seem to suggest that the establishment is not devoted to the care and preparation of human bodies, it should be a denial. If those factors weigh in favor of it being an establishment devoted to the care and preparation of dead human bodies, it should be an approval. That is the standard as to whether it checks that fixed place of business rule or checks that box or not.
Okay, I think my greatest concern with this, number one, back when these other establishments got their license, this was a different board with a different makeup. Today, we have a whole lot of different members. So a board they vote on their perspective. So we can't go back. I can't try and reason what a board did in 20, 21, 22, or 23. It's today, these are the board members. My greatest concern is there is not a private conference room. And the reason being, when we are waiting on families, there are times, certain aspects, the whole arrangements is considered confidential. So how can that be confidential with a table and you've got a desk? Who's going to be sitting at that desk? They're going to hear everything, the family. Is there that confidentiality that we are required to have with our families when making arrangements? Therein lies my greatest concern.
I am the only one ever in here. No kidding. This
I
is,
understand that, Ms. Sutherland, but let me say this. What about the FedEx man that might come in, someone come in bringing something, mailman? What's going to stop them from entering? I go back to what Mr. Gribble said. Every establishment we have approved since I've been on the board has had their own severance or a shared conference room for that reason.
there is no one on this floor besides myself. The I understand what you're saying, but I can't stress it enough. There is no one on this floor besides myself. And as I stated in that Mr. Shannon asked me to send, when I'm meeting with a family, of course, the doors are closed. And also there will be a sign on each of these doors that states that I'm conducting, business. I'm meeting with a family, an arrangement conference, and please call me, please call me. Do not come in, but please call me.
Ms. Sutherland, was your previous location in a like office, like a building like this, or was it a separate, its own building, or what kind of setup did you have there?
It was my own building. It was not mine. Of course, I rented it. And
Okay.
when it was time, when my lease was up, I leased it for 3 years, and when my lease was up, I did not, financially, I did not, they wanted to go in a different direction. And I was, of course, given the opportunity and did not feel like it was a good idea to sign another lease there.
What's an approximate number of families you serve a year?
250.
What's your percentage of those that you complete in the office? Just ballpark.
I would probably have to say 90%.
So I think that just to, and I don't want to speak on behalf of the entire board, but I would say the concern that is obviously our concern is the privacy of your conference area, just because of the um, delicate nature of what the funeral industry is and what would be doing, which I don't doubt that you understand that. I'm just saying this out, just speaking it out loud. And I think that um, in the last, since this board has been in place, since I've been on the board, um, the establishments that we've approved that were similar to yours either had was a multi-room suite where they had a private um, conference room, or where they had the option for a shared conference room that they reserved time in where it would still be completely private. And you know, that would be, I think, the concern of our board, because we have an obligation to the citizens of Tennessee to make sure that when they choose an establishment, that they will have the privacy and have the things they need at those establishments if we approve the licenses and things like that. So I just wanted, and I'm not speaking on turn of anybody else. I'm just trying to give you my thoughts, and I think that you have it's a nice office you have, but I'm concerned about that that it's just essentially one single room, because we all know how these things happen, and you can try as hard as you can to ensure privacy and ensure no interruptions, but ultimately we can't guarantee that, and even in things will arise at different times. um
If I can get a motion to either to deny or accept application.
And just to clarify, since we've kind of gone off key, the reason it's coming before us is because more or less it's not a single fixed place of business, correct? Nothing to do with the Treasury Department or anything on that. I want to make sure of what we're voting on.
Yes, it would be the board's determination as to whether the proposed new location satisfies the fixed place of business rule.
Let me ask you, if I turn this, if I were to, turn my business into online only, everything is done online and through email, would that make it any different? Like, there would be no one in this office but me.
So, Ms. Sutherland, I have an issue with that. You just stated that 90% of your families come in.
They did at my old location, yes.
So
But
how are
if
you
I
going to
had-
stop that if you're doing 90% business walk-in, as we would call it? How do you convert 90% to online only?
They will know, I will let them know that that is how I'm going to have to do it. I don't know. I understand what you're saying, but I'm here, okay? So I know how empty this floor is. It's just me. No kidding, it's just me. So I don't know what else to do. You know, I have followed every rule that I was told to. I have done everything I was told to. I have sent upwards of between 60 and 70 calls to another funeral home. I have followed all the rules. I've done everything I was supposed to. And I've been down now since March. And I'm just looking to, I thought I had found, I thought this was a good place. Never did I realize that it was not, that it was going to create, a problem for me.
Ms. Sullivan, it's not the number of people that's on the floor. It's the one room that we kind of like have a problem with. Board members, will y'all be, if she get a petition to kind of like separate the room? Because you, as a tenant, your landlord, he won't do anything to correct the issue as far as build a wall or anything for you, will he?
I do not know. I do not know if
Okay.
he will.
But you know
But
what I'm talking about, like a temporary
absolutely,
petition.
yes, I do. Yes, I do know what you're talking about. And, craziest thing, there was one here and he asked me if I wanted him to leave it or take it down. And he didn't put it up. It was a therapist that was in here before me, in this particular room. But yes, he asked me if I wanted him to have her to take it down or leave it. And I just said, well, take it down. One big room is fine. Never did I imagine that it was going to be an issue that I didn't have two rooms when it's just me and the family in here.
I mean, if they're in a conference room with a locked door, what's your guys' differences on having her office door locked? If that is, I'm just trying to, I guess, understand that part of it. Or what would a partition do?
The petition would kind of like, because the building the
Hey.
wall is not going to really help. Petition, if she has, like Mr. Wheeler said, FedEx should come, or if by chance if she have another customer to come back, they won't be able to see who may be there that's, making arrangements, with their loved one and everything. So they will have, with the little petition, if she put it to one end, the other, to where she kind of like block the,
So
the
if you're
cable.
blocking the view, it wouldn't have to be carpentry or fixed?
No,
Okay.
no.
I'm not sure blocking a view gives you the privacy. You can still hear what people are saying. The others all had a secured conference room that they could go to that allowed that privacy. That is my greatest concern, because we all know with certain deaths, be it a murder, suicide, that family deserves the utmost privacy, not for just anyone to know or hear what's being said. I, at this point, don't feel it's meeting the standard of what it should be for a fixed place of business.
We get a motion to deny her then?
I make the motion we deny because I don't feel it has met the standard.
Can I get a second? Motion failed for not having a second. Can I get a motion to approve?
Ms. Sutherland, let me ask you just my one question. You've heard all the comments here and the concerns and the privacy, et cetera.
Yes,
I do
sir.
know when you said you'd meet with a family, you'd have a sign on the door closed. It doesn't have to be fixed. Can you put a portable partition or something that would give that family some practice of privacy while at that conference room table? If anybody just walked in, they wouldn't see or what's going on or who's there.
Yes, I can do that. Also, hey, these two doors that I have, they lock. When I have a family in here, I can lock the doors. But yes, I can put up some type of partition. I sure can.
Mr. President, I'll make a motion that we accept recommendation for approval based on some type of partition that will visibly separate the conference table with the desk. And I think Mr. Gribble or Mr. Shannon could approve that on their own without coming back before us.
Can I get a second?
So, hold on a second. Before, what you said, what you read in the rule specifically pertains to preparation. Is that right? Can you read that one more time to me?
We got a motion on the floor.
So the rule is the board, in determining whether an applicant's proposed fixed place of business or establishment is devoted to the care and preparation of dead human bodies, may consider factors including, but not limited to, and then proceeds to list those factors.
Is it appropriate at this point where those factors can be listed to us so we can hear those factors?
Yes. A, any indication in the proposed establishment's name that suggests the establishment will be engaged in any activity other than the care and preparation of dead human bodies. B, any evidence at the proposed place of business that suggests activity other than that incidental to the care and preparation of dead human bodies. C, the type of professional signage displayed in connection with any goods or services provided within the establishment. D, if the establishment is located within a business complex, whether the establishment is clearly separated from any other entity located within the complex and clearly distinguished by professional signage. E, the volume of preparation services or commemorative services provided for non-human remains. And F, the type and or volume of advertising materials that offer preparation services or the commemorative services for non-human remains. And again, that list is not all encompassing. It is
Sure.
not limited
Can you
to.
read D again, please?
If the establishment is located within a business complex, whether the establishment is clearly separated from any other entity located within the complex and clearly distinguished by professional signage.
Mr. Gribble or Mr. Bryant, is there any way we can table this? Because it don't look like we're gonna come to an agreement this evening.
I need to withdraw the motion.
Yeah.
No second.
No second.
I think it is within the board's purview to table. It might, you're not required to, but it might be recommended of wherever you happen to be on the scale of no, yes, would be a yes if I were to see this. Maybe communicating to that with Ms. Sutherland would be beneficial, just so we're not in the exact same spot when we come back.
I would, Ms. Sutherland, I promise you that we're not trying to be difficult with you. We have an obligation, like I said, to, the public. And so, if there was some sort of, I don't want to use the word permanent, but some sort of separation of the area where the arrangement area is from the office, I would be more inclined to approve. But I really do think that it needs to be since you have the other entrance to that area, you almost need a wall. And I know you said it was there previously, and I hate that that was taken down, but
You, issue.
but I think that to go, at this point, I personally cannot approve. I cannot vote to approve as is. But if you can figure some kind of other alternative, I would love to see that personally.
Ms. Sullivan, if you could, get with the gentleman, that you rent from and see what kind of, petition that you guys can come up with. I'd say, permanent or, I'm gonna call it a temporary, petition, that little folding kind or something, to where we can have some kind of division in this room and come back to us. Because while we are tabling is because we have a problem with the room being open. And I understand everything that you said about the other people who was approved. And as Mr. Wheeler stated, it was different board members during that time. So if you can come with something to where you can satisfy this board, where this room has been divided, I don't think we'll have any problem with approving, you getting your license, well, not getting your license, but changing, your place of business.
Okay, so please let me ask you, it does not, do I understand you correctly? It does not have to be like permanent. You said basically some type of partition, but it doesn't have to be a permanent wall. Is that correct?
Yes, ma'am. So a permanent wall, yeah, that's what we would love to have, to be able to see is a permanent wall. But we all know that even with a permanent wall, you can definitely hear what goes on in the next room. So my concern is if you have an irate customer to come in, or if you have a FedEx man to come in, you have some form of petition there where you are blocking the faces of the people who are there making arrangements on with their loved one, so if we can have just some type of, petition to where it can go all the way across except for 36 inches to where you can have an entrance in and out of the two rooms. So if that been one of the little folding things or temporary things, or you may be able to get a accordion wall. You may be able to pick one of those up from one of these Savage companies that may fit.
And Mr. Naylor, will jump in real quick just for more of clarity for both me and perhaps Ms. Sutherland. So I think what you are saying is perfectly fine if you're saying this would satisfy me, this would get me to vote a yes. If your proposal is if we get this divider in place, then we will vote to approve. That can be done, but it has to be via motion to where it makes that divider contingent upon the approval. So if you're the former, I think you're totally fine, but I just wanted to make sure that Ms. Sutherland didn't end up in a position where she got that divider, came back and then still didn't get approved if it was not a motion, if that makes sense.
Will she have to present at the next board meeting, or if he satisfies that, can it be administratively approved?
I
That-
think it needs to come before the board.
Well,
Sorry.
that is,
Yeah.
that's the question as to whether it is a motion or not. If a motion is made and we get someone making the motion and then seconding it, and there are enough yeses on it, that says Ms. Sutherland gets this divider, we can send Mr. Shannon back out there to administratively approve it. If we have enough yeses, then yes, we can do that. If what we're saying is, no, we want a motion to table it, Ms. Sutherland, please go get a divider, come back at the next meeting and we'll review at that time. Those are two different motions.
My motion is still on the floor to provide the divider.
Mr. Lee.
Sorry, you just got on me. My motion is still on the floor to provide the motion to recommend with the providing a divider and to be administratively approved. I can withdraw that, but was my motion earlier.
Is that essentially what you're saying?
Mr. Whitley, Mr. Lee, you could make the motion again, but you withdrew your motion.
Yeah, you withdrew it.
Yeah,
Yeah,
you
you
did.
withdrew it. Yeah.
I'll make a motion that we recommend approval of the change of location by a temporary wall or divider being placed between the conference room and the desk. And if it satisfies what we're asking, that it can be administratively approved without coming back before the board.
I'll second that motion.
It's been moved by Mr. Lee and second by, I want to call you Randy.
Mr. Nash.
Nash, by Mr. Nash. All those in favor? A sign of aye.
Aye.
Opposed, have the same.
No.
Motion carried. So, Ms. Sullivan, do you understand what we're asking?
Yes.
Okay.
Okay, so the divider that you're asking for, whether it's a permanent wall or whether it's an accordion divider, either of those is satisfactory. Is that correct?
Yes, ma'am, that would be left up to, because we're gonna send the inspector back out.
Right.
Yes,
No,
ma'am.
I understand, but all I'm saying is, okay, either an accordion divider or a permanent wall, either one will be satisfactory.
Yes, ma'am.
Okay. All right.
Are we good, Mr. Brown?
Yes.
Next thing we had is new business 2027 board meetings dates. Mr. Gribble.
Those dates before you are the dates of the second Tuesday of each month,
Right.
January through December, which is typically what the board approves. Some of them will probably wind up being canceled. Some of them will be held virtually, more than likely, but those are the dates. We need to, go ahead and ask the board to approve those so that we can put them on the website and let people know when the next next set of meetings will be held.
I make a motion, we approve those dates.
Second the motion.
Been moved by Mr. Wheeler, second by Mr. Nash, that for 2027, that our board meeting will be the second Tuesday of every month. All those in favor, sign of aye.
Aye.
Opposed, have the same. That's everything. If I can get a motion to adjourn.
Mr. Naylor,
Oh, I'm sorry. Sorry.
you have to see if anybody had any comments.
Any public, do we have anybody online?
No, sir.
Okay. Have any public comment?
No, sir.
Okay. Can I get a motion?
Motion to adjourn.
To adjourn. All right. Want to thank you all. Meeting adjourned.